Page number 9, serial number 57 and 58. Page number 10, serial number 59 to 64. Page number 11, serial number 65 to 72.
70. You informed respondents? Alraj is there. Inform ಮಾಡಿದ್ದೀರಾ?
That's the legal matters. Documentation.
75 at the request of counsel for responding. Released on 30th. 31st. 39. Preliminary hearing. Agree. Two weeks ಆದ್ಮೇಲೆ ಅಷ್ಟೇ. 39 at the request of counsel for the petitioner released on 22nd November.
For being spoken to serial number 1, that is for
Dated 17/23, 72 hours.
Matter is being moved for being spoken to. Now, counsel for the petitioner submits that in para A of para A of para 3, at line 3, the date of the order has been wrongly mentioned as 17/12 instead of 17/2/2023. The title of the petition indicates that the date of the order is 17/2/2023 and submission is accepted. If that date is corrected, registry is directed to issue a fresh certified copy with the date corrected.
order serial number 2, H.N. Basuraju.
I am for the second amendment. But report is ready, my lord. I will file it in for some time, my lord. It is ready. I will file it in arrest.
When will you file it?
Lord, reopening day, I will file it. Now it is ready, my lord, because
I am appearing for the petitioner in this case.
Copy ಕೊಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ, ಇನ್ನು ಸರ್ವಿಸ್ ಮಾಡಿಲ್ಲ.
That counsel for respondent number 2 submits that seeks for a week's time to file the inspection report after service thereof on the counsel for the petitioner. Released on 9th November.
please.
Much obliged.
Serial number 3, Reshma Kamaya and collected by.
My lords, I appear for the petitioners, my lords. I am instructed not to appear in this matter anymore. I have issued the NOC, my lords.
Yes. It's also submit that you will be appearing for the petitioner in 3. Have you filed your wakalatnama? If wakalatnama is filed, registry that print his name as such and delete the name of Ms. Reshma Kamaya as that appearing for the petitioner. What about the affidavit? File a memo of appearance. Statement of objection 5 ವರ್ಷ ಬರಲ್ಲ. So 5 ವರ್ಷ served unrepresented. Whatever the process that you are going to follow, if you file it, should record it so that it becomes SOP for your office also. What about objections? Your file. Anybody else wants to file objections? Learned AGA, learned Additional Advocate General submits an affidavit as regards the process to be followed on service of notice on a government institution. Would be filed given 2 weeks' time. Released on 8th November.
Serial number 4. Documents.
Office objection comply madilla ನೀವು ಇನ್ನ 2018 ಇಂದ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇಟ್ಕೊಂಡಿದ್ರೆ ಹೆಂಗೆ?
And affidavit of reason. They itself thought that the case is not made. They will went out.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆಯೋ ಎಲ್ಲಿದೆಯೋ ನಮಗೆ ಗೊತ್ತಿಲ್ಲ, ಇಲ್ಲಿರ್ಬೇಕು. When the matter is called. When the matter is called, you have to be there, counsel. You cannot assume reach ಆಗಲ್ಲ. ಹಂಗೆ ಎಲ್ರೂ ಅಸ್ಯೂಮ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರೆ ಏನ್ ಮಾಡೋದು? ನಾವು ಅಸ್ಯೂಮ್ ಮಾಡ್ಕೊಂಡು ಹೋಗಿ ರೀಚ್ ಆಗಲ್ಲ. And do that. You are ready for argument now? If you are ready for argument now, we will recall it. Pass over. Court fee has not been paid. In similar prayer.
Residents of the as well as residents of the nearby petition.
For each of the petitioners, you have to pay a court fee. If you pay only 100 rupees for one petition, it won't. So each petitioner has to pay. ಯಾವಾಗ ಮಾಡ್ತೀರಾ? 4 weeks. That counsel for the petitioner seeks for and is granted 4 weeks time to comply with office objection. Released on 27th November. Yes. Yes. ಹೇಳಿ. ಯಾವಾಗ ಫೈಲ್ ಮಾಡಿದೀರಾ? Not taking any steps. ಯಾವತ್ತು ಫೈಲ್ ಮಾಡಿದೀರಾ? 5/7/23. Have you served a copy on the other side? That is the office objection which was raised 2 years ago. ನೀವು ಹೊಸ ಯಾವ್ದು ಫೈಲ್ ಮಾಡಿರೋ ವಕಾಲತ್ತು? ಯಾವ ವಕಾಲತ್ತು? The acknowledgement is the 5-7. Illilla, we don't see your wakalatnama.
Copy serve.
ಈ ಅಪ್ಲಿಕೇಶನ್ ಇದೆ ವಕಾಲತ್ನಾಮ ವಕಾಲತ್ನಾಮ ಇದೆಯಾ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇದೆಯಾ ನೋಡಿ this is as regard the application ವಕಾಲತ್ನಾಮ ಯಾವತ್ತು ಹಾಕಿದ್ವಿ ಅಪ್ಲಿಕೇಶನ್ ಜೊತೆ ವಕಾಲತ್ ಇಲ್ಲಪ್ಪ ಇಲ್ಲಿ ಹಾಕಿದಿರಾನು ಇಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದೀವಿ ನೋಡಿ ವಕಾಲತ್ನಾಮ ಅಪ್ಲಿಕೇಶನ್ ಜೊತೆ ಹಾಕ್ತೀರಾ ಸಪರೇಟ್ ಆಗಿ ಹಾಕ್ತೀರಾ ನಿಮ್ಮ ಕಂಟೆನ್ಷನ್ ನೀವು ವಕಾಲತ್ನಾಮ ಹಾಕಿದ್ರೇನು ಯುವರ್ ನೇಮ್ ವಾಸ್ ನಾಟ್ ರಿಫ್ಲೆಕ್ಟೆಡ್ ಇನ್ ದ ಕಾಸ್ ಲಿಸ್ಟ್ ಅಂತ ವೇರ್ ಇಸ್ ಯುವರ್ ವಕಾಲತ್ನಾಮ your wakalatnama is there, you are right. Application jote antira, it is not there along with the application. So even as on today, there is no wakalatnama. ನಿಮ್ಮ ಇಂಡೆಕ್ಸ್ ಅಲ್ಲೂ ವಕಾಲತ್ನಾಮ ಇಲ್ಲ ಮತ್ತೆ to file a wakalatnama now. It is not there on record. The so-and-so submit that he had filed a wakalatnama for the proposed legal representative of petitioner on 5/7/2023, along with the application and order 22 rule 4. However, a perusal thereof indicates that there is no such wakalatnama enclosed along with the said application. Faced with the above situation, he seeks for and is granted 2 weeks time to file a fresh wakalatnama. Released on 9th November.
Page number 5.
File model. This is how to file wakalatnama. Who is going to see this? Indal irbeku illa bere memo jote irbeku tane. See, Yogesh K submitted the wakalatnama which had been filed along with the application and order 22 rule 4 had not been considered and his name not shown in the cause list. As such, on the earlier occasion he could not appear. Registry is direct print the name of Sri Yogesh K as that appearing for the applicant in IA 1 of 23. Copy bandidya? Serve a copy. He is directed to serve a copy. So recorded bandi. Copy, sir. We'll bring them on record. For a legal representative, why do you want to file an objection? What is your objection? He is the son. Copy thereof has been served on counsel for respond number 3 and 4. Accepting the reasons stated in support of the said application.
Dismiss agade.
He's taken a sorry. Since the name of the petitioner had not been shown in the cause list on 4th September 2023, there is bona fide reason for him not to appear on that day. As such, the order dated 4th September 2023 dismissing the above petition for non-prosecution is recalled. IA 1 of 2023 is allowed. Accepting the reasons stated in support of IA 1 of 2023, the person named therein is brought on record as the legal representative of deceased petitioner as P1A. Counsel for the petitioner to carry out necessary amendment and file amended cause title. Relist on 9th November.
Serial number 7. Petitioner.
Huh? What is the cost?
The layout is.
Hmm.
30% of the sites will not be released by government.
Photographs produce madbekaitalla. How is it? Learned counsel for respondent number 4 has filed a memo with the estimation of cost. In view thereof, the presence of respondent number 4 is exempted. Learned counsel for the petitioner. It bandre bekagilla. Learned counsel for the petitioner seeks for and is granted 2 weeks time to go through the same and make a submission. Released on 10th November. Yes. Actually, 30th October ಗೆ ಇದೆ ಇವತ್ತು ಲಿಸ್ಟ್ ಆಯ್ತು. ಮೂವ್ ಮಾಡಿದ್ದು. Court all moved ಅಂತಿದೆ. When you ask them to produce a document, you can't move it in between. How can you move it in between? The matter had been adjourned to 30th October while order date 29/9. Sri B.J. Somyaji submits that by that date the file would be produced. Released on 30th October, interim order earlier granted is exempted. Don't unnecessarily do this.
Serial number 9. Badrinath.
Aro. Yes. You are satisfied? You had various idalla adike. The petitioner is before this court seeking for the following reliefs. During the pendency of the above matter, a memo has been filed by the learned AGA enclosing the guidelines issued by municipal administration. The director municipal administration dated 25/9/2023 indicating the guidelines, indicating the manner in which RO-based water treatment systems have to be set up, as also the responsibilities of the urban local bodies relating thereto. In that view of the matter, and the considered opinion that in that view of the matter, the counsel for the petitioner submits that the relief sought for have been satisfied and there is no further grievance so long as the said guidelines are implemented. Accepting the said memo and the guidelines, the petition is disposed. Liberty is however reserved to the petitioner to approach this court in the event of the said guidelines not being followed or implemented.
regarding that the distance should be guidelines should have mentioned here. It should not be established. They have to obtain the ISI certificate as well as the Bureau of Indian Standards.
That they'll have to implement that. So now you can, in view of this guidelines, you can give a complaint to that. They'll have to consider that.
Number 10.
This is that. You're filing? You're filing what?
I had to amend the amendment.
Told.
Seeking the fashion.
Counsel for the petitioner has filed. Then if you are challenging this, then that impeding application ought to have been allowed properly.
No, this is what they are finding now.
Counsel for the petitioner has filed an application for amendment. A copy thereof is served on the counsels for the respondent who seek for and are granted 3 weeks time to file their respective objections. Released on 9th November. Once again, a submission is made by counsel for respondent number 4 that the copy of the petition has not been furnished. If the copy is not furnished, line what that. Dismissal and bandavagle Bharat Kap. He has not even filed Wakalat Nama, Mr. Counsel. One copy could have kept. Yes.
Number 11. Number
6 to 12.
11th October.
I was told the question. I'm including matter in TV ಮಾಡಿದ್ದಾರೆ but I'm mistake not the thing.
Let us senior come. We will pass over. So you are not carrying out any construction.
Objection actually.
ಆಮೇಲೆ ಜೊತೆ one single order will pass.
Number 12. Also here.
Yes. You are appearing for whom, Mr. Regde?
I am appearing for respondent number 3 and 4. Who the alleged malord is violating the impleading bylaws.
What about the inspection, Mr. This property was finally identified.
Yes.
That is the one.
Yes, yes.
So here, petitioners seeking malord. They actually respect of 10 acres of land.
Iburuno, you are competing with the weight of papers.
The malord has caused the local standard of the petitioner malord has to be located.
Yes.
As to what is his right over the 10 acres of the property. And whether malord all the owners of the property have been made a party of part. Because malord, I am claiming right to take respect of 2 acres of the property.
What is your grievance as regard the locus?
Petitioner has no right over the 10 acres of property malord which he is claiming. I, my lord, represent only in respect of 2 acres of the property. There is civil dispute, my lord, which was pending between the petitioner and the respondent. Suit for their injunction was filed by the petitioner, that was dismissed. RA was filed, RA was dismissed, RSA was filed, that has been dismissed. There is a clear finding that, my lord, in respect of my property is concerned, he has no right to that property. However, my lord, subsequently, since he interfered with the possession of the property, my lord, I have filed a suit for declaration in respect of 2 acres of the property. Now, in respect of other 8 acres of the property is concerned, I have no right or interest. I was, my lord, granted 4 acres of property, 2 acres are already sold. In respect of 1 acre of property, I have found a layout and registered changes have been
Sold.
before this court.
So 2 acres have been sold.
Yes, 2 acres, my lord, I am running a school. More than 1,000 students are there. Now, his grievance is that, my lord, the building is in violation. He does not say which building, he says entire 10 acres. Now, first time, my lord, he has to
Has that
show.
building, particular building been inspected, Mr. Karthikeyan? Where is,
None of the building has any plan.
none of them have any.
None of the entire 10 acres. The entire- I am, my lord, not representing the entire 10 acres. Let my lord.
Local standing, what is this?
Local standing.
Mr. Does your client have a plan sanction?
Lord, as on that day when we have taken a plan, it was a panchayat land, we have taken plan from the panchayat and produced it. And I am running the school on the basis of that. The education department has given me permission, I have produced those records also.
You have produced a plan sanction from the panchayat.
Yes, my lord, I have produced it.
Where page number?
The page 132, my lord, is the
You have to give us typed copies of all these. We can't.
yes, my lord. 87, my lord, is the panchayat land.
87. For stitching no sari illa, you file it and the papers are coming out.
Yes, my lord, I will.
87. You go through this and make your submission, Mr. Karthikeyan, these are the issues which are also coming up. This panchayat plan, we have directed another matter also. What is the veracity? Panchayat issues a plan, people construct, then you say that is not a plan, or you don't have it. So what happens in those circumstances? What is the validity of the panchayat plan?
This BBMP area, my lord, he started a building, my lord, not under the BBMP area.
Were not those documents handed over to BBMP? You are the custodian. ಬಂದಿಲ್ಲ ನೀವು ತಗೊಂಡ್ಬೇಕಲ್ಲ CMC ಇಂದ ಇಲ್ಲ ಪಂಚಾಯತ್ ಇಂದ. 2007 all these things came into your BBMP limits. You have got 150 villages, 7 TMCs, so many CMCs came into your jurisdiction. Did not you take the handover of the documents? What to do after say 16 years? What happened to the documents with those CMCs and panchayats? Administrative, you notified. See the problems. Did with a good intention, but they don't have and they don't recognize anything. ಅವ್ರ ಹತ್ರ ಇರೋದೇ ರೆಕಗ್ನೈಸ್ ಮಾಡಲ್ಲ ಅವರು. ಅವ್ರ ಹತ್ರ ಇದ್ದವ್ರು ಕೇಳ್ತಾರೆ ಪ್ಲಾನ್ ಕೊಡಿ ಅಂತ. ಇದು
Basically, there are 3 things. Bangalore metropolitan area, then Bangalore metropolitan area, then Bangalore metropolitan region. In that region, there are several tower pockets. Once a notification is issued under the Karnataka Tower Contempt, all the subsidiary bodies have no power. And this plan says there is no date this plan. Therefore, once the entire cabinet parts of the piece will be enacted, BDA, that's corporation area, then the BDA area, then another Bangalore metropolitan region development authority act. That in that area, what is called Bangalore International Airport Planning Authority. Vasco Planning Authority, then separate some sort of a satellite planning authority. Therefore, it has to come within those planning authorities only. Planning. Panchayat has no power to sanction such a map of the plan.
Before 2007, before all these things came, we verify that. You see this,
Then not take any action. What has been filed. Until the map is burned, a lot of, they have done an inspection, report has been filed. Next one is also.
We'll hear you and then
Till that time, a lot of resentment, there's a pen drive also.
counsel for learned, counsel for respond number
3 and 4.
2 is filed a memo of compliance. Copy thereof is being served on the counsel for the petitioner and respond number 3 and 4.
What is one is?
You'll 3 kg kodavakali, Karthik. This 3 kilos you have to give to both.
They don't know.
To both.
They don't know. Partition.
And this 5 kilos will also come to both.
The actual demolition, my friend only says in paragraph 29 that I have a right to proceed under PPMT Act. I filed a representation. All that I have talked about are mandamus.
In here, you file whatever you want to
Yes,
file on this. There's a considerable number of documents which have been filed. It should not be that we pass some order without looking into it. We'll look into it.
Yes,
If you want to say something, you say it.
certainly.
That counsel for respond number 3 and 4, though is ready with the statement of objections, it is seen that many of the documents are not legible. As such, he submits that statement of objection with legible copies would be filed within a period of 10 days from today, after serving a copy thereof on the counsel for the petitioner and respond and the other respondents. The said objections to be filed on or before 31st October. Rejoinder, if any, to be filed on or before. How long will it take, Ms. Basraj?
But since the copy is already served, I'll file it within that.
Documents I can't style again, not there anymore. Some of those documents cannot even be seen. Rejoinder, if any, to be filed on or before 15th November, relist on 21st November. Since the inspection report has already been placed on record indicating the nature of construction and location of construction, and some issues are being raised in the objections, the action proposed to be taken by respond number 2 is deferred till the next date of hearing.
I leave till us.
Because this plan issue is, we'll have to see.
Yes. Last is-
Basuni. Since it is a self-acquired property, you may even be entitled for 50% of the share in the property. Only so now but one of your children has objected to it.
Objecting, then it should not be, but she should have filed a suit.
Have you made them a party?
She said, but they responded to the three.
You have any other children?
There's a four children, they have no objection.
So
Only
make them,
one.
make the party, let them file their no objection. You also have to place on record what is the policy as regards life interest. For lease.
That others are in fact by any statutory form not. If not, my lord, whether there is any circular document for that.
This is going to be an important issue for a lot of people.
Yes, yes.
Life interests are being created. And that life interest cannot be enjoyed properly without the Khata also. So if you don't have a policy, you'll have to come up with a policy.
R2 is asking for a registered real estate. And she doesn't have right at that.
ಏನು ಪಾಲಿಸಿನೇ ಇಲ್ಲ ಅಲ್ಲಿ.
That order.
Either accept or reject. You don't have anything and but you'll have to look at what is the, when will you file that? Will make your other children also a party, Mr. Basu. So that there no objection is placed on record. And only insofar as this will.
Only application. I have produced.
You have said Pavati Khate. Pavati Khate ಆಗಿ ಅರ್ಜಿ ಕೊಟ್ಟಿದ್ದೀವಿ ಅಂತ. ಪಾವತಿ ಅಂದ್ರೆ ಫುಲ್ ರೈಟ್ ಅಂತಾನೆ. Page number 18. Then again is a transfer of Khata. That also does not provide for this.
Based on this application, they are in student endorsement connection here. We said page number 12. Right, publish in page number. Page number 11. Endorsement. ಸರ್ಕಾರಿ ಸ್ವತ್ತಿನ ಬಗ್ಗೆ ಶ್ರೀಮತಿ ಲತಾ ಅವರು ಖಾತಾ ವರ್ಗಾವಣೆ ಬಗ್ಗೆ ಆಕ್ಷೇಪಣೆ ಸಲ್ಲಿಸುತ್ತಾರೆ.
Yes, but there is no provision for recognizing your application also, and even the online Khata application does not provide for it. So you'll have to submit on both. She learned counsel for respond number 1 and 2 has filed a memo enclosing the representation furnished by the petitioner as also the representation stroke objection submitted by respond number 3. The same is taken on record. In the present case, the petitioner being the wife of the deceased owner of the property had submitted an application for change of Khata in her name on the basis of a will executed by her husband, her deceased husband. Correct. In terms of the said will, the petitioner has been conferred a life interest in the property, and thereafter the property would devolve on the children. The petitioner having 4 children, one of them has been made a party as respond number 3 since she has objected to the application. However, the other children have not been made a party. Faced with the above situation, Shri Balasubramanian, counsel for the petitioner, seeks for and is granted 2 weeks' time to file necessary application to implead them. Shri Mallikarjun Reddy, counsel for respond number 1 and 2, submits that there is no particular policy, there is no particular statute which is available on record permitting transfer, permitting issuance of Khata in favor of a person who has a life interest in the property. He, however, submits in that in contractual matters like lease, etc., lease or mortgage, etc., the corporation issues a holder's khata in favor of the lessee stroke mortgagee. Correct. The aspect relating to life interest being conferred on one of the deceased spouses under a will or any other document has come into vogue now. As such, it would be required for the corporation to place on record the methodology that it would follow in such circumstances. And if no policy is available to formulate such a policy. Shri Mallikarjun Reddy seeks for and is granted 3 weeks' time to place such policy and or make submission in relation thereto. Released on 23rd November. That's the new application.
Under 149(2), in the event of death of any person, primary liable person to whom the right of the deceased shall be transferred, as or other shall give notice to the such transfer to the chief commissioner. Then they are duty bound. Let's say whenever
Transfer is different, Mr. Basu. Life interest is different. Life interest, there is no transfer.
the Khata is independent.
The Khata also is affected only on a transfer. We understand you want Khata, but life interest only transfer agar. You don't become the owner. You only have a.
Right class.
You don't get the title. You only have an enjoyment on the property. But right now, unfortunately, they have not done it till now. You should have done it by now. Why is it not for so many years? We don't know.
No, is that?
The transfer will be in future. The will has come into force with the death, but the transfer is not in presently because there is a in-between period of life interest which is created. It is only on the petitioner's expiry that the transfer would be affected in future, whenever that is. So even today, there is no transfer in favor of those 4 children.
They don't have right.
They don't get any ownership right.
Taking that. Denies the execution of the village.
Yes, the child.
Handling the situation that is.
Then that has to be challenged.
Placing this on record. That being-
Unless there's an order of the court which is placed before you, if an order is placed before you, you are bound by it. But otherwise, what is the policy?
I understand.
So would you transfer it now in their name and also make an endorsement that so and so have a right in the property because everybody's interests are to be protected? You'll have to look at
Yes.
various permutation combinations.
I think before this.
Impossible that it has not arisen. It would have arisen. People might not have not approached the court. Nor bitu, you make your submission. But ask your officers to apply their mind and look at all the permutation combinations. Yeah, really. Disposed matter. We'll see it at the end once more. You can, we'll see what it's there and we'll pass. You want 3 weeks time. Laws of R3.
Laws of RPL. He's got the second one, so that's filed the objection. Out of the party.
ಮತ್ತೆ ಇಲ್ಲಿ ಎಲ್ಲಾರು ಅಂತ ಬರ್ದು ಬಿಟ್ಟಿದ್ದಾರೆ.
Other
You are appearing for whom?
Third respondent.
Objector and of the.
Third respondent is hospital.
Third respondent.
Application for impleading. The objectors has been filed. Issue notice thereon returnable by. Emergent notice thereon returnable by 24th November. Notice over one thing larger. Notice gets served before that, Mr. Council. Matte it will get adjourned. Pay the process fee immediately. What is?
15. Here be it.
You are appearing now. Sure. So what is this one?
What is happening about here? I think this street vendors is being built by the people. That is also being answered by the parking structure of the shop.
At the request of counsel for the petitioner, relist on 23rd November. Yadu connect with so and so. For clarification, umbrella, cement umbrella. They are related to same place. We have it on that day. Let us see what happens. You can produce that. Connect button.
Here number 16.
Yes. Yes.
They believe that respondent has approached the
Hmm.
last page.
Yes. Page 8.
Didn't follow the
Page 8.
last page.
Last page ಅಲ್ಲಿ ಒಂದು ದೊಡ್ಡ ಪ್ಲಾನ್ ಇದೆ ಒಂದು ಚಿಕ್ಕದೊಂದು ದೊಡ್ಡ ಪ್ಲಾನ್. Yes.
The extent of encroachment is going across n and on. 1.2 meters long.
The violation that too with respect to cannot.
Whatever the violation is, you have to remove. Setbacks have to. This is not only encroachment. This is encroachment ಆದ್ಮೇಲೆ setback ಬಿಡಬೇಕು. ಆ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಹೋಗುತ್ತೆ.
Concerns the plan. Concerns the plan. The violation is 6.36.
Madam, this is the construction which is the encroachment
Yes.
or setback. What about setback?
That has come to the. That's what it is.
The question will rephrase the question. The question is,
Yes.
if this sajja is removed,
Yes.
then the setback is proper.
Even the parking area, setback is also in.
ಮತ್ತೆ ಅದು ಹೇಳಿಲ್ವಲ್ಲ ನೀವು. See, what you have to submit is what is to be done to bring it in compliance with the building bylaws. Good. What is to be done to bring it in consonance?
coming in the way of.
We understand that.
Yes.
Now,
If that-
if Sajja is to be removed, if Sajja is removed, everything else is proper. ಅದೇ ಹೇಳಿ. So ಏನೇನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಅವ್ರಿಗೆ ಹೇಳಿದ್ರೆ, then they will be, they can make the submission on that. Parking area. Parking area, there's no construction, so you can park in your setback.
Their own report, they have applied to the petition. They say there is no violation as respect to the setback. It's a connection.
Your report does not speak of setback violation.
Act is shown. Clearly indicating what they have marked. Very difficult to the standard.
Sajja is fine, madam. Now park the Sajja. You are saying that the parking, because of parking, or there is a setback deviation otherwise also, because of construction. So ಅದು mark ಮಾಡಿಲ್ವಲ್ಲ ನೀವು? Where have you shown it? Page, yeah, petition ಅಲ್ಲ ನಿಮ್ಮ memo ಅಲ್ಲ? Where, along with this page number? Yes. 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 Page 8. Yes. So is it your case that the parking cannot be used, setback area cannot be used for parking? It comes in the setback area. That is why we are asking you. Cannot parking be made in the setback area? We are under the impression parking can be made. So if parking can be made in the setback area, it cannot be a deviation. If the setback area itself is reduced and construction is put up in the setback area, then there's a deviation. So what is the case here? Is it that there's a construction in setback area or is it used for parking? That is not shown in your. Not what you have stated here. Canopy, Sajja, whatever. English shall canopy, Kannada Sajja. So Sajja tegidre, setback ella correct agata? Yes, now you can make it. If it only Sajja to be removed, remove. Whatever violation is violation. No reasons. Why we are asking you that is if there is setbackal construction is adu tegibe. But if there is no construction in setback, there is no prohibition for use of it as parking. Inspection report. A memo enclosing the inspection report, master, photographs, license, and sketch has been produced. Copy thereof has been furnished to the counsel for the petitioner and respond number 6. The submission of learned AGA is that there is a canopy stroke chajja which is protruding in the setback area. and also comes on to the abutting road. And as such, the same being in deviation of the plan sanction would have to be removed. And apart thereof, there is no other deviation. The counsel for the petitioner also confirms the said submission. Faced with the above situation, counsel for respondent number 6 seeks for and is granted 2 weeks time to obtain instruction, make a submission as to when the canopy stroke sajja will be removed. Released on 9th November.
17. Ravi Kumar objection.
Copy ಕೊಟ್ಟಿದ್ದೀರಾ? When will you consider that trend? So if that is not in accordance with the building bylaws?
15% now.
Yes. You got a certification from them.
Main grievance would be pertains to the issue that where they have been encroaching and they have not been using the fact and they have not been such a resolution. Therefore, the report is filed by the team, but it does not talk about the violation. It talks about the Khata and the other things. But there is
Because when there is no plan saying everything is violated.
so
now-
in the representation by lordship was wishes, but then to obtain a license. But to the effect that as far as the illegal construction is concerned, that it has to be.
That is what we will deal with. So once their plan is considered and sanctioned as per the building bylaws, whatever deviations will be pointed out, those deviations will be removed by you within a period of. Yes. Your deviations ಬಂದ ಮೇಲೆ violations ಬಂದ ಮೇಲೆ we are not concerned with their grievance, we are concerned with the building bylaws. They may have a lot of grievance, if not supported by building bylaws, that grievance we won't consider. Building bylaws have to be satisfied. Village Go law applies, Mr. Counsel. Law will apply to everywhere, you will have to follow the law. Ashte. As long as the law is there, you will have to follow it. Khata you will obtain. Khata is a different issue. You will obtain Khata. You file a complaint against us. You look at yourself now. Mr. Surendra Kumar, you have been alleged to have violated. You have violated it without a plan sanction. You have put up a construction. You speak of your violation. If you have a complaint against the petitioner, you can file it elsewhere. That is always available to you. Look at, please make your submission as regards your violation. Without making that submission, pointing fingers there won't help you. That they will determine now.
Very difficult in much of the start of the construction, despite of the deferral and the other than the executor, proceeding with the construction.
Now it is stopped, Allah.
Complaint before the police station. And they are stopped the construction.
You can't take the law into your hands like this.
Yes, making allegation in this video.
You have been given an opportunity opportunity to rectify your mistakes or your violations. If you don't want that opportunity, that can be taken away. There's no problem. The entire building will go. He has no authority to do so. We have a plan sanction for a work order. Don't persist with these submissions. Please safeguard your client's interest. Don't do this, which will affect your client. Legally, anything adu maadi. As for building bylaws, you are entitled to construct. Please construct to the fullest extent, but not more. If there's any violation, they'll point it out. You will have to remove it. We are asking you in how much time you will remove it. Or we'll keep the petition pending to monitor it. We'll monitor it. A memo has been filed by the council for respond number 123, indicating that on inspection of the property of the petitioner, the said construction of the petitioner is found to be in order. Insofar as Khata not having been obtained by the petitioner, the counsel for the petition submitted that necessary application will be made to obtain the setback. Khata idea.
The computer Khata was issued in the
That council for respond number 4 to 6 has submitted a plan for approval in terms of the building bylaws on yav submit madam. 20th of September. In the event of application anta madidvi. Application bandidella. Sorry, one nimsha illide. Adu record agilla. I was submitted a plan sanction on 20th September 2023. That council for respond number 1 to 3 submit that the same would be considered within a period of 2 weeks from today and sanctioned in accordance with the building laws applicable. After doing so, respond number 1 to 3 will cause one other inspection of the property of respond number 1 to 3 to verify if the construction carried out is in accordance with the plan sanctioned. If not, mark the areas which are in violation or deviation of the plan sanctions to building bylaws, which the petitioner undertakes to remove. Relist on the respondents, respond 4 to 6 undertakes to remove. Relist on 16th November for reporting the progress.
Serial number 8.
You have filed. UDDS. You've received copy. Then AG has filed an affidavit of the Undersecretary Urban Development Department in enclosing certain documents. Same has been served on the counsel for the petitioner who seeks for and is granted 2 weeks time to make a submission. Learned counsel for respondent number 4 seeks for and is granted 2 weeks time to file the affidavit of respondent number 4 as directed by the order dated 31/8/2023. The said affidavit to be filed on or before 31st October 2023, failing which respondent number 4 shall be personally present before this court on the next date of hearing.
The secretary is there also the copy. The respondent.
One copy ಕೊಟ್ಬಿಡಿ. Mail ಇಷ್ಟೊಂದು ಅಂದ್ರೆ to be the depends on the mail receiving capacity. 5 MB ಅಂದ್ರೆ ಹೋಗಲ್ಲ. All of you will have to increase the mail size. Earlier we would not, it's e-filing. 25 MB minimum ಇರಬೇಕು.
30 pounds. DPR.
RDPR?
RDPR. Direction.
RDPR ದು ಇದೆಯಾ?
RDPR.
So RDPR ಯಾವಾಗ ಫೈಲ್ ಮಾಡ್ತಾರೆ? Learned AG was filed an affidavit of undersecretary Daikala. Then she seeks for 2 weeks time to file the affidavit of the on behalf of the Rural Development and Panchayat Raj Department. Only Yogesh Naik. Released on 23rd November. Interim order earlier granted is extended. Connect with so and so. Date idea adike. Connect with so and adralella. So same affidavit will apply, but the property issues will be different. In this, as regards this particular property, there are a number of petitions. Connect with so and so. ಒಬ್ಬರು ಕಟ್ಟಿದ್ರೇನು ಸಾಕು. Imagine the plight. Naik, why do you require any complaint? If some violation is there, you take action. You cannot know that somebody complained, therefore we took action and Telakaga. So whatever complaints you want to make against the panchayat, you make. You make it as to what they are not doing. So we'll direct them to do that henceforth. Or the state will have to direct each of you to do what you have to do. Because you have the planning authority blaming the panchayat, panchayat blaming the UDT, UDT blaming the planning authority. Then finally blaming the Panchayat Raj department, PDO, EO. So what is the role of each of you? What is the role of the PDO, EO as regards this particular aspect? You place everything on it. See, if you remember it right, in this case, there was a plan which has been sanctioned in persons of which Mr. Prakash's client by the panchayat. Mr. Prakash's client purchased it. Thereafter, there is one more plan which has been sanctioned by the by the planning authority. Okay, reverse. Planning authority approves it. Thereafter, the panchayat also approves it. How can they do it? While doing so, their right in that site goes. Without even hearing them, without telling them anything, nothing. So what is the value of it? There may be unscrupulous people coming to your authorities to do this. But if the authorities do it, paper, now what plan you had sanctioned, the panchayat needs to know about it. And once you come into being, panchayat has no business. Have you informed the sub-registrar? And is it been put up with the sub-registrar that these should not be registered because they come under you? That is what the state will have to tell us. You cancel Martira, madam, that's all post-mortem. After the death, we are looking at healing, not causing the death. See, if once the planning authority comes into being, should not the sub-registrar take into account these aspects that it is coming under planning authority? Without that plan, they should not register. Because they have come into being, panchayat does whatever it wants, they register, sub-registrar registers it. Then later, this planning authority says, I have not given permission. That is when you sanction the plan. When you are not sanctioned, what happens? New Year at stage 5. In the stage 1 only Devi. So you give us what it is. For all three of you, because all three of you are stakeholders in this panchayat, planning authority and the state. Land lidre, which is not coming under the planning authority, what has to happen? Coming under the planning authority, what has to happen? What is the role of each of you? What will be the right of the purchaser? Somewhere it has to be clearly put in place. '76 FF. What is KTCP Act? This is regularization. We are looking at following the law. This is regularization after violation. You in a post-mortem ginta aamel vada. See, we have to look at preventive steps that these kind of things don't happen. And people don't. What will see if they when did you buy it, Mr. Prakash?
2008.
How much did you pay? Whatever they have paid, 2006. That money, even if they get back, they won't be able to buy that property today. Because in 17 years, 16 years, it is increased. And they would have taken a loan on it, which they have been repaying till now. No property, no money, pay the loan. The practical difficulties which are there because there's no coordination amongst your departments.
One though they will give a plan. Whether there is no planning authority. There is no planning.
Place it on record. Place it on record. Place it on record. We'll deal with it. Seriatim will pull it across so that at least it's there in some place. We don't know whether Mr. Prakash will succeed or not. At least somebody else will not suffer. Whatever grievance you have against your fellow departments, place it. First matter.
Collected when?
30th October ಇದೆಯಾ ಅಷ್ಟೊಳಗೆ affidavit file ಮಾಡಿಲ್ಲ 30th October. First matter. As being spoken.
19.
Inspection.
Still construction is going on. We have advanced it because of the fact. Corporation sent us a letter. There's no plan. Construction is going on. The only indicators that there is no plan.
If there's no plan or violation of the plan, construction has to be stopped. ನಿಮ್ಮ ಲೆಟರ್ ಆಯ್ತು ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ. Their office is not related. Let counsel for the petitioner submits that the assistant executive engineer, while it's dated at 25, additional director town planning south, while dated at 25/9/2023, has informed the petitioner that there is no plan which has been sanctioned in respect to the subject property. This court, while order dated 25/9/2023, had observed and had directed that the assistant executive engineer shall ensure that no construction to happen, no further construction to happen if there is no plan sanction or there is any deviation. Since the additional director town planning has categorically indicated that there is no plan sanction, the construction would have to be stopped. Shri Pawan Kumar submits that necessary instruction will be given to the concerned to ensure immediate action. Released on 25th October. You have filed wakalatnama. Registry right, print the name of Shri Suraj Sampath as that appearing for the petitioner and delete the name of, along with or delete? Delete the name of Shri Tammaya HN as that appearing for the petitioner.
Serial number 20. Channel is now.
What are the right copy of this? K page number? Land. ಏನು ಅಂತ ಆನ್ಸರ್ ಬರ್ತೀನಿ. ಹೇಳಿ ಇವಾಗ ಏನು?
There was interference with by the located in a mountain. Setback to LI. They started to make a construction of they demolished their construction. They started taking up. The plan is here's some connection.
They violated it, is your second.
Three floors here, permission. 5 floors permission.
How is your construction?
The construction is money at the neighbor. I am not put up any construction.
Well,
Neighbor.
We'll cause your property inspection also. Issue notice to respond number 1 and 2 returnable by 24th November The Pawan Kumar accepts notice for respond number 3 to 7. Respond number 6 is directed to cause the inspection of the property of the petitioner bearing number 935/10 second main road, 4th block, Rajanagar, Bangalore, 560010. As also the property of respond number 1 and 2, namely property bearing number 936/9 second main road, 4th block, Rajanagar, Bangalore, 560010, to ascertain so and so. The inspection to be carried out commencing from 10:30 a.m. on 31st October 2023. Report to be submitted on or before 10th November 2023, after furnishing copy thereof to the counsel for the petitioner. In the event of the construction being found to be in deviation of the sanctioned plan, respond number 6 and task force no madida. So task force can take action to stop construction. Task force BBMP. BBMP doesn't have a task force. Partial. 6 and 7 to ensure that there is no further construction which takes place. Process fee and copies to be furnished by end of day 16th October. Failing which the interim order will stand automatically vacated. Same. Otherly, accepting the submission of counsel for the petitioner of his objection is overruled. Either no, that 21. Yes. What about your construction? Same. Yeah. What about your construction? In the passage. Yeah, there is no problem. Pawan Kumar accepts notice for respond number 1 to 4. Issue notice to respond number 5, returnable by 23rd November. Respond number 4 shall cause the inspection of the property of the petitioner bearing number 5/1, second floor, MM Road, Batranpura, Bangalore 560026. As also the property of the respondent number 5 bearing number. What is the property details of respond number 5? Bearing number 5. MM Road, Batranpura, Bangalore. To ascertain.
But they are not taking any action. Based on the banking. There was a temporary order. 7/2023. And another order is the confirming order was from the past.
You should mention that.
15/7/2023. But they were not taken any action. And still they are continuing with the construction.
Inspection done. The Pawan Kumar seeks for and is granted 2 weeks time to obtain instruction, make a submission as to what actions have been taken by the statutory respondents in terms of Annexure G being the confirmatory order under section 248(3) of BBMP Act 2020, dated 15/7/2023. We list on 16th November. Since a confirmatory order has already been issued under subsection 3 of section 248, respondent number 3 shall ensure that there is no further construction which takes place. Process fee and copies to be furnished by end of day 16th October. Failing the interim order will stand automatically vacated.
Bill number 22, Julian.
What was bought on the Impleading auction?
Yes,
After the launch of the directive, which is permitted me to
participate. Yes,
Not only those people who had the EMT amount without dealing with participants. Notwithstanding the order of the nevertheless, not concerned those aspects. Because my inspection from the other petitioners who were not successful, they don't want to continue with the property because the rents are way too high and beyond their
so
expectations.
which are those petitioners don't want to continue?
Petition number 1 and petition number 4 have been successful.
1 and 4 are successful.
The other petitioners don't want to press.
2, 3, 5, and 6 don't want
They
it.
don't want the other petition and other similar situations because they are secured with some other papers also. They want to find the. I only request your lordship to kindly grant me some accommodation in the name of protection. And vacate the property and also according to the.
How long do you want to vacate?
Considering two aspects. Lordship, I kindly see petition number 1, petition number 2 below. The panchayat are liable to pay 3 lakh, which is not in for the supply to it be 20 from past year. That's one aspect. The second aspect is petition number 5. Have bills not. Today I have about 2,75,000 of bill, which is still pending consideration to be paid to petition number 5. Even if they pay the bills, they are ready to get the property. Notwithstanding those facts, they are ready to vacate the property right now. I will request the lordship to kindly accommodate 6 months time.
If the payment is made, you'll vacate right now. If payment is not made, you want 6 months.
For the other petition, I mean, property then for past period. Not just a kindly grant me 6 months, but I'll vacate the property.
Fourth respondent may be deleted.
Which power is that?
So ಇವಾಗ ಯಾರನ್ನ delete ಮಾಡಿ? ಈ BJ Somyaji has filed wakalatnama for respondent number 1 to 3. Registry is direct delete name of Shri MS Devraj as that 1 to 3. He submits that respondent number the office made party as respondent number, the authority made party as respondent number 4 does not exist. As such, respondent number 4 is deleted from the array of parties. Registry is also directed to delete the name of Shri MS Devraj as that appearing for respondent number 4. Now, counsel for the petitioner submits that respondent number 1 and petition number 1 and 4 have participated in the auction and have been successful. Insofar as petition number 2, 3, 5, and 6 are concerned, they have been unsuccessful, but they unsuccessful participate madilva.
They will not even submit it. Even after that, I will not.
You are only recording your submission. There is no dispute of recording. So 2, 3, 5, and 6 have participated not.
They did not even participate, not even permitted to.
Respondent petition number 2, 3, 5, and 6 have not participated in the auction. He submits that since they have been in the property for quite some time, and the amounts which are due from respondent number submission
From the panchayat.
from respondent number 3, 6 months time be granted for them to vacate. That is your submission.
That's why.
They are due for payment. How they?
The BJ Somyaji learned counsel for respondent number 1 to 3 submits that there is no due which are owed by them to the petitioner, but to the contra, the petitioners owe huge amounts of money to respond number 3. Both the parties to reconcile their accounts and make their submissions by next date of hearing, released on 9th November. Copy of the 2 sets of the petition along with annexures to be furnished to Sri Vijay Somyaji by end of day 16th October. In the meanwhile, office objections to be complied with. Yes. You're being dispossessed.
I'm not being dispossessed. The order says that they want to take possession of the property.
You want the interim order to state disposition.
Yes.
The Pawan Kumar accepts notice for respond number 1 to 4. The respondents are restrained from dispossessing petitioner till the next date of hearing. Office objections to be complied.
That there is no objection. I've made submission.
What is annexure J?
Annexure J is improved order. Page 46. Certified copy of the on C.
In your prayer, you mentioned so many numbers. Where do we find that numbers?
69, 23, 24 is the order dated 25/9/2023.
Yes.
Now your last may kindly turn to annexure G, the notice which they have issued.
Mr. Counsel, please come to your prayer.
Yes,
You have mentioned D.JC/RRN.
that
Where is
there.
it in the order?
My lord, may kindly see in page 30 pardon, in page 30.
Yes.
That is the number Patranathan K. Vaja 775 of 2324. That is a Patrana Sankhya that they have shown. Subsequently, they change it and show it as 69 of 2324. That's why I have that.
You asked for stay of annexure J, quashing of annexure J. Does annexure J have that number? So why do you mention unnecessary numbers?
I will read it.
And office objection raised, Madhuri, you are saying, no, that is correct. Your submission are also very,
I'm sorry.
the office is also this court. Don't regard the office as something else.
I will correct.
If the office is raising some objections, if they are not correct, you can make your submission on that. But you can't make these kind of submissions. Can you do that?
Yes, they have. Better shown 2 numbers.
That you make it in your pleading,
I made it.
not in your prayer. And office raises a legitimate.
I remove it.
You can't do this. You comply with the office objection by 31st October. Objections, if any, to be filed on or before 9th November, released on 17th. Yes. State. Stay of disposition, not the order.
24. Manoharian.
You are not covered, it's state now. That order is state now. You are a little late. 248.3, you're not gone before the commissioner.
Yes,
Go before the commissioner.
already, this state director town planning.
That order is stayed now. You'll have to go before the commissioner. We'll reserve that liberty to you. The Pawan Kumar accepts notice for respond number 1 and 2. The petitioner is before this court seeking for the following release. The contention of the counsel for the petitioner is that the orders passed under section 248(1), the notice under section 248(1), the provisional order under section 248(2), and the confirmatory order under section 248(3) have been passed by the assistant executive engineer, who has no jurisdiction to do so under section 248. The said orders, the petitioner has an alternative efficacious remedy of challenging said orders under section 253 of the BBMP Act 2023. Reserving liberty to do so, the petition stands disposed. Same.
26. Other than
Serial number 25, respondent, Your Honor.
We are disposed with the liberty to appeal.
Much obliged.
Yes. Idu same, 248(3). Appeal. No notice has been. Affixture is service, Mr. Counsel. 3 has been affixed, 248(1) and 2 has not been given to you. Ada affix agidya 248(1). Very 248. Where to produce? The Pawan Kumar accepts notice for respond number 1 to 4. The grievance of the petitioner is that the petitioner was not served with the notices under section 248(1) and 248(2), and without such service and without providing an opportunity to the petitioner, the confirmatory order under section 248(3) has been issued. In that view of the matter, the operation of the order under section 248(3) at annexure. Annexure? Annexure F is stayed. 248(3) under dated 7/8/23 at annexure F is stayed till the next date of hearing. The counsel for the respondent to produce the records, the original file pertaining to service of 248(1) and 248(2 notice. We list on 9th November.
Yes, also it was not just pasted.
Pasted is service. 248(1) and 2 ಬಂದಿಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. ನಿಮ್ದು 3 ಬಂದಿದೆ ಅಂತ ಹೇಳಿ. ಅದಕ್ಕೆ ಬರ.
Pasted on the door of the building.
Pasted is good enough because that is where you are constructing.
Yes.
So obviously you should know about it.
57. Legal report.
How is your construction, madam? How is your construction? You put up construction? Vacant from. Shri Pawan Kumar accepts notice for respond number 1 to 4. And AGA accepts notice for respond number 5. Issue notice to respond number 6 to 11. Returnable by 22nd November. Respond number 4. To cause inspection of the property of the petitioner bearing survey number 158, new survey number 158/4, Kagdaspura village, Rattur Rogli, Bangalore, East Taluk, Bangalore. As also the property 158, petition number 1 bearing number so and so, petition number 2 bearing survey number 158, new survey number 158/4, And the property of respondents bearing survey number 157. Sadgaspura village, K.R.Puram Obli, Bangalore, East Taluk. To ascertain if there is any plan sanction, so on. So the inspection to be carried out commencing from 10:30 a.m. on 31st October 2023. Report to be submitted on or before 9 November 2023 after furnishing copy thereof to the council for the petitioner. In the event of the construction being found to be without plan sanction or in deviation of the plan sanction granted, respondent number 4 shall ensure that there is no further construction carried out. Process fee and copies to be furnished by end of day 16th October, failing with the interim order will stand automatically. Petitioner is 158 and 158 bar 4. Yes. Where have you said that? Para 2, you said 157. Where have you said that in the petition? Yes. 7. Where have you stated? 157 we have here. So 157 and comma 158 bar 2-1. Ashtena? Petition number 1 and 2, 158. 8 bar 4. First one. How many comma? In the meanwhile, office objection to be complied.
Serial number 28. Allegation.
No? Notice has been served on you.
Notice for the notice committee 248 clause 1 minor, then my provisional order has not been passed, have not been implemented. So that my they have stated that in the annexed H, that ongoing construction.
248, 1 has been served. Now you go on appeal under 253.
The reason is because of my I have not given up here on the court order which I submitted.
That you go on 253. If 248 is not served, then we'll stay. If that is served, you are replied.
Allegation is constructed building. There are managing that.
Constructed or under construction, if there's a violation, there's a violation, Mr. Nagar.
But 248 plus 2
248 has not been complied. You complied and you are illa anta idire. Where is the order on 248? Page.
Page number.
Serve aitu, they have not been heard anta.
39.
It does not indicate that. You go under 253.
Real notice as in item number 26.
This you have been served, you have replied. Your contention is your reply has not been accepted. Your construction is completed, whereas in the notice it is said that it is ongoing. That is what you are saying. So that is something which you have to agitate in 253. You can't come here. You can't come here for that.
Order has not been.
Petitioner is before this court seeking for the following. The contention of the counsel for the petitioner is that the reply issued by the petitioner to the notice under section 248(1) and 2 has not been properly considered by the respondent. Number 4.
Here, my God, court respondent has no authority to pass an order.
ಅದು ಆಲ್ರೆಡಿ ಸ್ಟೇ ಆಗಿದೆ ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಏನು ಮಾಡೋದು? Considered by respondent number 4 while passing the order under section 2, subsection 3 of section 248, inasmuch as the petitioner had categorically stated that the construction had been completed in the year 2016 and that there is no ongoing construction. The said aspect being a factual aspect, the petitioner having an alternative efficacy remedy in terms of an appeal to the Chief Commissioner under section 253 of the BBMP Act 2020, reserving such liberty, the petition stands disposed.
Because I am about to start the challenge that particular court respondent is the executive engineer. But the knowledge
That has been stated, Mr. Counsel.
is
Many times we have said.
59.
in this matter, 248,000 and other than 48,000 are on the.
Not been so. That you have a ground. The Shri Pawan Kumar accepts notice for respondent number 1 to 4. The grievance of the petitioner is that the petitioner, without serving notice under section 248(1), section 248(2 of the BBMP Act 2020, the confirmatory order under section 248(3) has been passed by respondent number 4. In that view of the matter, operation of the confirmatory order dated 15/9/2023 at Annexure F is stated to the next date of hearing. The counsel for the respondent is directed to produce the original files of records pertaining to service of section 248(1) and 248(2) notice. We list on 9 November.
50 hours.
When the file comes.
Hearing alleged, serial number 30. Udika Ishwar Bhatt.
Favorably, respondent number that is in Israel. Based on that license, he has to get the construction. I have produced a terrace copy and all, as well as the board for example.
Any objection for dispensation? Accepting the reasons stated in support of IA 1 of 2020, there being no dispute insofar as Annexure C is concerned. The production of certified copy of Annexure C is dispensed with. Yes.
Seeking for direction to the respondents. That is especially respondent number 5. Because the road, Panchayat road was encroached by the Ishwar Gowda. He is no more during the he passed away and his grandson is made as respondent number 6 in the present petition. And there is an encroachment. He encroached the road and put up the construction in violation of the license issued by the Gram Panchayat. And they have, I subsequently, because there no action was taken, I approached the Talak Panchayat and revenue inspector inspected the property.
In Panchayat to Majal. ये pronunciation के problem है. Golda Majal. ಅಂದ್ರೆ ಏನ್ ಅರ್ಥ ಏನದು? ಏನಿಲ್ಲ.
Majal means the place, level place in Majal ಅಂತ. That is
level place. Golda ಅಂದ್ರೆ round ಆಗಿದೆ.
Majal is unbelievable Majal.
Who appears for respondent number 5?
I am
In violation idea, encroachment idea.
no dispute is and
You found there to be encroachment.
The same amount it is in order, actually E1, page 42. Page 42, actually E1. ಉತ್ತಮಜರು ಗ್ರಾಮ ಪಂಚಾಯತ್ ಕಚೇರಿಯಿಂದ ಗೌತಮಜರು ಗ್ರಾಮದ ಕೊಳಕೇರಿ ನಿವಾಸಿ ಈಶ್ವರಗೌಡ ಬಿ ದೇವೇಗೌಡ ಅವರಿಗೆ ಮನೆ ಕಟ್ಟಡಕ್ಕೆ ನೀಡಿರುವ ಪರವಾನಗಿಯನ್ನು ಪರಿಶೀಲಿಸಬೇಕಾಗಿದೆ ಅರ್ಜಿಯನ್ನು ಸತ್ಯ ಸ್ಥಳ ತನಿಖೆ ಮಾಡಿ ನಿಮ್ಮ ಸಂಬಂಧ ಪರಿಶೀಲಿಸಬೇಕು. ಅರ್ಜಿದಾರ ಈಶ್ವರಗೌಡ ಬಿ ದೇವೇಗೌಡ ಅವರು ಗೌತಮಜರು ಗ್ರಾಮದ ಸರಳ 60/7 ಫೀಟ್ 0.10 ಎಕರೆ ಜಮೀನು ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಆದೇಶವನ್ನು ಪರಿವರ್ತನೆ ಮಾಡಿ ಗ್ರಾಮ ಪಂಚಾಯತ್ನಿಂದ ಉಪಗ್ರಹ ಮತ್ತು ದೃಢೀಕರಣ ಪತ್ರ ಪಡೆದುಕೊಂಡಿರುವುದರಿಂದ ಸತ್ಯವರ 0.10 ಎಕರೆ ಜಮೀನಿಗೆ ಪರಿವರ್ತನೆ ನಕಾಶೆಯಲ್ಲಿ ಕಾಣಿಸಲಾಗಲಿದೆ. 14 ಫೀಟ್ನ ರಸ್ತೆ ಸಂಪರ್ಕ ಇರುವುದು ಹಾಗೆ ಅದಕ್ಕೆ ತಾಗಿಕೊಂಡು ಅವರದೇ ಪಟ್ಟಾ ಜಮೀನು ಪಾರಿ ಇರುವುದರಿಂದ ಸತ್ಯವರಿಗೆ ನೀಡಲಾದ ಕಟ್ಟಡ ಪರವಾನಗಿಯನ್ನು ರದ್ದುಪಡಿಸಬೇಕಾಗುತ್ತದೆ ಅಗತ್ಯವಿರುವುದಿಲ್ಲವೇ?
There is nothing about encroachment of the road in this.
They say my lord, the construction is within my ownership.
No, my lord.
They are only saying that you're being, the sanction plan was given for this, which is your ownership.
Yes, ma'am.
They are not speaking anything about encroachment, which is the allegation. We'll cause an inspection of this property, do an inspection.
My lord, inspection filed. That kindly see.
Nimma report, we won't take into
No
account.
report, revenue inspector. Yes, but the revenue inspector has filed the report. Kindly see annexure.
On the same reading, my lord, OS number 262 of
My lord,
2007 was
G1,
filed.
kindly see G1. G1 is the, on the lyric sheet. Or
Page
the
number,
type of copy at
page
page number
number?
50. At page number 50, type the copy.
50.
Page number 50. Hey, read.
Where is the sketch?
Uh,
Thirty. That is the plan.
that is
Plan has been
the.
sanctioned. Now the allegation is in persons of that construction has been made on the road.
My lord, this is the report and the revenue
Interesting, my
inspector.
lord.
And also, village accountant has filed the report. That is the election G2, G1 and G2.
We'll cause an inspection, both of you be present there.
In fact, my lord, a suit, my lord, for the same really finding OS 262 of 2007.
Suit could be for a private remedy. This is also a road. If it is not a road and if you encroach his property, you would not have a ground. You encroached, the allegation is that you encroached a road.
My lord,
They are duty bound to protect that.
my lord, my access to my property.
That's a private right, you have filed the suit.
And my lord, my defense was that it was a private road, not a panchayat.
No, Panchayat maintained road because they have already themselves.
We asked them to give that. The condition of the petitioner is that the respondent number 6 has put up a construction.
My lord, Ishwaragowda has put up a construction.
The
That is
respondent
this
number
man,
6
yes, no more.
predecessor
Please.
in
yes,
interest
Yes.
has put up construction on what road is it called?
Private roads. Not my lord.
On a road which he claims to be a public road maintained by the fourth respondent, fifth respondent, leading up to his property in survey number 60/7, leading up to his property, the road being situated in survey number 60/7 of Goltamajalu village. The contention of the council for respondent number 6 is that it's a private road, and furthermore that there is no encroachment of the road. The property has been constructed within the private property of respondent number 6. In order to ascertain the veracity of both the statements, respondent number 5 is directed to cause an inspection of the said road passing through survey number 60/7 of Goltamajalu village to ascertain and make a submission as to whether the said road is a public road and or is maintained by fourth respondent, fifth respondent, and the fifth respondent. Fifth respondent And as also to make it, as also to indicate, as also to measure the property, measure the road and verify if there's any construction carried out by the predecessor of respondent number 6 on the said road. If so, what is the action proposed to be taken by respondent number 5? The inspection measurement to be carried out commencing from 10:30 AM on 31st October 2023. Since the order is passed in the presence of both the counsel for the petitioner and respondent number 5, they are entitled to participate in the said inspection and measurement. In the event of either of them not participating, they would not be entitled for any will not be entitled to claim any equities. Report to be submitted on or before 10th November after furnishing copy to the counsel for the petitioner and respondent number 5, relist on 17th November.
Revenue inspector also person because that it should be observed.
Let us surveyor.
Surveyor, here the papers.
Name and submission. Width of the road should be noted from the beginning.
That road Ellinda Shuruagi Ellinda end ಆಗುತ್ತೆ.
ಆ ಜಾಗದಲ್ಲಿ ಮಾತ್ರ ಕಡಿಮೆ.
How long is the road? Width is small, length ಎಷ್ಟಿದೆ road?
He encroached that where his house is situated, he encroached.
The width of the road along the length of it.
31.
Mr. Naveen, respond number 3 and respond number 4. Respond number 4, 3 and 4 have not entered appearance. What to do with them? Local self-government, local state government. 30 now. This complete, they have no regard at all for any proceedings filed against. One ನಿಮಿಷ ಇದೆ ಅದ್ರಲ್ಲಿ we'll make a note so it will same 30 ಅಲ್ಲಿ respond number 3 Zilla Panchayat, the executive officer Zilla Panchayat, and respond number 4 the Taluk Panchayat, those served have remained unrepresented. The AGA is directed to bring the above to the notice of the Principal Secretary, Rural Development and Panchayat Raj Department, since in many matters, the Zilla Panchayat, Taluk Panchayat or Gram Panchayat, those served continue to remain unrepresented and there is no assistance being rendered to this court. Yes, 31.
Across values. My application was rejected a year only on the road once. After this notification, I obtained a permission from Karnataka State Tourism Department. Before that, I got the permission from Karnataka State Tourism Department. But license is from 2018. I have only about my residence from 2018. That is not in.
Where is it?
First, at election, the endorsement that is issued by rear road is an official change page number 40.
Page?
40.
It's only dealing with 21, 22. That you are not getting it because you are not being registered on that. And your submission on the last occasion was that you have been in operation from 2018. Therefore, you have to be granted. Now, this request has been rejected for the reason that you got the registration only on 3/12/2022. So if you have a registration prior to it, you have to furnish it. If you don't furnish it, there's no registration. Positive fact you have to give. Do you have a trade license from 2018? You took time to produce it. So, Where have you produced it? When? Two thousand 18. Again, instructions were for Mr. Paul. They are registered. Web hosting is left to you. They don't need registration with tourism to conduct a hotel business. You have given them a trade license. This 2,000 square feet hotel restaurant. How can you insist on that? This is a COVID-19 measure. If there's a hotel which is being run, you are giving that facility or that rebate because of the lockdown and people were not going to hotels and restaurants. So provided you can't discriminate. Counsel for the petitioner has filed a memo dated 11/10/2023 enclosing the trade licenses issued by the BBMP from the year 2018-19 onwards. And as such, his submission is that the petitioner being in the business from the year 2018-19 is also entitled to the reliefs on the rebates on tax granted by the BBMP during the COVID-19 pandemic. Counsel for the petitioner, counsel for respondent number 3 seeks for and is granted 10 days time to obtain instruction, make a submission, released on 25th October.
Number 34.
Yes. Ground floor apartment is converted into commercial. That is why the association is started. The Pawan Kumar accepts notice for respond number 1. Issue notice. Shri Pravinji Adgati has entered as accepts notice for respond number 2. Issue notice to respond number 3, returnable by 25th October 2023. The grievance of the petitioner is that respond number 3 is running a commercial business in a residential apartment. Right number apartment. Apartment number? Namely apartment number 31 and 3 apartments. 31, how can it be ground floor? 3 would be third floor only. Apartment number 3 and 4 situated in the ground floor of block number ಏನಿದೆ? ಒಂದೇ ಬಿಲ್ಡಿಂಗ್ ಇದೆಯಾ 4-5 ಬಿಲ್ಡಿಂಗ್ ಇದೆ? ಒಂದೇ ಬಿಲ್ಡಿಂಗ್. In apartment number 3 and 4 of the apartment building SJR Residency situated at number 19, 20, 31 and 32 First Main Road, ITI Layout, KK Layout, Nagarbavi. Respond number 1 is directed to cause inspection to ascertain the veracity of the submission made by the counsel for the petitioner. In the event of any commercial activity taking place in the said premises. Respondent number 1 shall ensure that no such commercial activity takes place. Process fee and copies. The inspection to be carried out commencing from 10:30 a.m. on 30th October. Report to be filed on or before 9th, released on 16th November. Process fee and copies to be furnished by end of day 16th. The interim order will stand automatically. Okay.
33. By executive.
Yes.
Petitioners are, minimum family that are living cannot be responding numbers definition. Because the issue is very simple. You know, the problem is burial ground attached to the respondent of the church. And the bodies have been being buried for several years now. You know, that has been causing a lot of issues in the residents of the respondent member 7 church. You know, in 2019, they started extending the burial ground till the doorsteps of the petition. Your Lordship, if I could, there have been several representations, several complaints given by the residents.
Is it within the property of the church?
Yes, Your Lord.
Then how can you find fault with it?
Your Lord, there is, if I could take you to Your Lordship, the annexure E of my petition.
Yes.
The district health officer has already given a report.
Hmm.
Your Lord, at page number 36. If I could show you, Your Lordship, that medical Abhishek is somebody's Sunday.
Page number?
Page number 36, Your Lordship, the type copy that you.
36. Yes.
Medical Abhishek is somebody's Sunday. Immediately Gramada Vaidyathikari ಸಂಬಂಧಪಟ್ಟು ಆರೋಗ್ಯ ಸಹಾಯಕರೊಂದಿಗೆ ಸ್ಥಳ ಪರಿಶೀಲನೆ ಮಾಡಲಾಯಿತು. ಯಾವ ಗ್ರಾಮ ಪಂಚಾಯಿತಿಯ ವ್ಯಾಪ್ತಿಯ ಸೇಂಟ್ ಫ್ರಾನ್ಸಿಸ್ ಡೇವಿಯರ್ ಚರ್ಚ್ನ ಸ್ಮಶಾನ ವಿಸ್ತರಿಸುವ ಸ್ಥಳದ ಪಕ್ಕದಲ್ಲಿ ಜನವಾಸತಿ ಮನೆಗಳು ಕಂಡುಬರುತ್ತದೆ. ಸ್ಮಶಾನದ ಆವರಣ ಗೋಡೆಯಿಂದ ಅಂದಾಜು 8 ಅಡಿ ಅಂತರದಲ್ಲಿ ಕುಡಿಯುವ ನೀರಿನ ಬಾವಿ ಇರುವುದು ಕಂಡುಬರುತ್ತದೆ. ಸ್ಮಶಾನವು ಕುಡಿಯುವ ನೀರಿನ ಬಾವಿಯಿಂದ 250 ಮೀಟರ್ ಅಂತರದಲ್ಲಿರಬೇಕು ಎನ್ನುವುದು WHO ಗೈಡ್ಲೈನ್ಸ್ ಆಗಿರುವುದು. This is as per the WHO guidelines, the distance between the well, the burial ground and the dwelling houses, all the well should be 50 meters. Here it is nearly 2.4 meters from the house.
The well is for agriculture purposes. That is a different. You are being supplied water by the corporation or using this well for drinking water?
Drinking water. The petitioner right there are almost 50 to 60 residents. But one more thing I would like to.
The dead also have to find place, madam. Along with the living, the dead also have to find place.
You're right, Your Lord. Your Lord, if I can take you to the provisions of Karnataka Gram Panchayat
We'll hear them and then we'll see what is to be.
Because if they start burying your dead, the construction is completed now, Your Lord. So, Your Lord, I can show you the provision under section 94 of the Gram Swaraj Act.
Yes.
Your Lord, the Act provides that.
If they are setting up a new burial ground, that's different. There's the
They
existing
are
burial ground.
extending the burial ground.
It is within their property.
It is in violation of provision section 95.
We'll also have to read.
it.
90?
Section 95.
Yes.
No person shall in any panchayat area bury, burn, or otherwise dispose of or cause of suffer to be buried, burned, or otherwise dispose of any corpse in any place within 100 meters of a dwelling place or any sort of drinking water supply other than a place registered under section 90 or licensed under section 93 or provided by Gram Panchayat.
Was the burial ground there before you constructed your house or after that?
You know, so extension has happened since 2019. The church has been existing since years. And you know, it is in confirmation of this provision. You know, it says
We'll hear them and then we'll see what is to be.
you know, if the construction is almost completed, let
Let
it not
it
worry at least
Let it be, let it be.
extended.
And AGA accepts notice for respond number 1, Uduvara Udupi. Ashok Nayak accepts notice for respond number, no. 2 to
You know,
4.
once the corpse is buried, there is no way to relocate the corpse to any
You
other place.
cannot claim, you have no vested right. 2 to 4, 2 to 4. AGA for 5 District health officer will come under you, madam, or under the panchayat? AGA for 156. Ashok Naik for 224. Issue notice to respond number 7. Written by emergent notice to respond number 7 written by 9th November. We pay the process fee immediately. Tumagana. AGA accepts notice for 1. AV Gangadharappa for 2. 34. 37 AGA same. 42. One ನಿಮಿಷ ಇವ್ರು ಮುಗಿಸ್ಬಿಡೋಣ. 42.
34, 37, 42.
48. 48 ಇಲ್ಲ. Yes. 41 and 53. ಇದು ನೋಡೋಣ ನಾವು ನೋಡೋಣ. ನಿಮ್ಮ ಹತ್ರನೂ ಇಲ್ಲ ಕಾಪಿ, ನಮ್ಮ ಹತ್ರ. What?
And there is an order in this behalf to measure the property for certain health measurement. There is an order. And we try to reach a communication.
Bomnalli, Bidrulli Ogli, Bomnalli yaar. M. Pradeep is directed to accept notice for respond number 1, 2, 3, counsel for the petitioner to serve 2 sets of the petition along with annexures.
This order saw the measurement may be protected during pregnancy.
Hear them and do it. How can we do that now?
So that is no individual person, the officers.
Serve it on him, let him come. You list on. That's why we are telling you, the standing councils are known. Why don't you give it to them? At least they'll get the instruction. M. Pradeep. He list on 9th November. Council.
Notice also ordered.
M. Pradeep, standing council. Standing council's name is M. Pradeep. Or Kodi.
ನಂಬರ್ ಕೊಟ್ಟನೆ ಅವ್ರ ಬಟ್ಟೆ ಹೊಸ ಬಟ್ಟೆ ಕರ್ಕೊಂಡ್ ಬರ್ಬೇಕ್ರಿ. ಗಾರ್ಡನ್ ಕರ್ಕೊಂಡ್ ಬರ್ಬೇಕು.
Illegal construction. Nimma construction. How is your construction?
I am a neighbor.
Yes, how is your construction?
Not think of any construction.
The construction that you have put up is proper. We'll cause your inspection also, your property's inspection.
No. What has happened, you are asking for they have openly sanctioned to build only up to 3rd floor.
What about your construction? Is it proper?
Yeah, absolutely proper and it's a good old construction.
Pawan Kumar accepts notice for respond number 1, 2, 3. Issue notice to respond number 4, returnable by 23rd November. Respond number 2 on the assistant jurisdiction assistant executive engineer directed cause inspection of the property of the petitioner bearing number 776, 15th main, 100 feet Ring Road, JP Nagar, first phase, Bangalore 560076. As also the property of respond number 4. Bearing number 775, 15th cross, JP Nagar, first phase, Bangalore 56078, to ascertain so and so. Inspection to be done on 31st, 10:30, 31st, report 9th. In the event of the construction being found to be made without a plan sanction or in violation of the plan sanction, respond number 3 shall ensure that there is no further construction which takes place. Process fee and copies to be furnished by end of day 16th, failing with the interim order will stand automatically vacated.
Copy is served on the finger.
In on set, third set.
38.
Mr. Gunjal. Also, hmm.
That measurement was best method was altered with the panchayat. Without voting, page 15.
15.
From the top what was actually in the other state was mentioned 43 in respect of my property, it is altered. This 43 has been altered to 13.5 to 23.5. It should have been.
Yes.
There is a division into 3 brothers. After this alteration, a notice has been issued at instance of the neighbor that have encroached 3 feet towards west of the property a road.
What is the total property measurement?
43 into 51.
Total which belong to the family.
That is the 40. Totally will not comes to 110.
Illy count madbedi. Total extent claim in. What are the property belonging to the entire family?
Entire family will
ಇದು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿ ಹೇಳ್ತಾ ಇದ್ದೀರಾ ಅದು ಬೇಡ ನಮ್ಗೆ ನಿಮ್ಗೆ ಗೊತ್ತು ಯಾಕೆ ಕೇಳ್ತಾ ಇದ್ದೀರಾ ವಾಟ್ ಇಸ್ ದ ಟೋಟಲ್ ಎಕ್ಸ್ಟೆಂಟ್ ಬಿಲಾಂಗಿಂಗ್ 128 into 21.5. It is 2,752, 2.5 guntas.
Now, this 43 change into 30 now, and 21 is changed to 23 now. Towards the north. It should have been 21 now. Continue.
Yes.
Now, at the basis of this matter, a notice has been issued by the second respondent that I went from 33 feet towards west of the property, alleging that it is a public road. There is no road as such towards the west of my property. A gully is there. It is for the benefit of the family members, but the gully is there.
Gully is also a road.
5 feet. 5 feet is there, you know. 3 feet I have access to that. 5 feet is there, gully, the village manner.
So your 5 feet to gully extent continues to be the same answer.
The notice has been issued to demolish 3 feet towards west of the property.
If you are not encroached, then the construction cannot be there.
There is no construction. There is no encroachment. Construction within the measurement.
Photographs
Even when there is in case of dispute matter, the matter has to be referred to Assist Commission Section 211 of the Act.
That everybody raises a dispute. That doesn't mean that everything is pending on that. You can't encroach a road. Gully is also a road.
But 5 feet is the same matter. I have not encroached that.
Photographs are the source. You will see that if you have the photographs. So it's not only you, several other people will get affected if you get into the road.
Notice itself, HSC, they themselves say, HSC.
Yes.
Annexure page 18, annexure B. Annexure D, page 18.
ಎರಡನೇ ತಿಳುವಳಿಕೆ ಒಂದನೇದಲ್ಲಿದೆ
ಮಧ್ಯದಲ್ಲಿ ಸ್ಥಳ ಪರಿಶೀಲಿಸಿ ಉಪಯುಕ್ತ ತಿಳುವಳಿಕೆ ಪತ್ರ ನೀಡಿ ತಮಗಳ ಸಮಕ್ಷಮದ ಅಳತೆ ಮಾಡಿ ತಾವುಗಳು ಬೀದಿಗೆ ಕೈಯಾರು ಗೋಡೆ ಪೂರ್ವ ಪಶ್ಚಿಮ 11 ಅಡಿ ನಿರ್ಮಿಸಿದ ಗೋಡೆ ಪೈಕಿ 3 ಅಡಿ ಒಡೆದು 8 ಅಡಿ ಉಳಿಸಿಕೊಳ್ಳುವಂತೆ ತೀರ್ಮಾನಿಸಿದ್ದಾರೆ. ಅದರಲ್ಲಿ ತಾವುಗಳು ತಳಮಹಲ ಸಹಿ ಮಾಡಿದ್ದರೂ ಸಹ ಹೆಚ್ಚುವರಿ ಇರುವ 3 ಅಡಿ ಜಾಗವನ್ನು ತೆರವುಗೊಳಿಸಿದೆ. ಸೌಕರ್ಯ ಸಮಿತಿಯಿಂದ appointed. Therefore, 5 feet is there. Road, ಬನ್ನಿ.
5 feet ರೋಡ್ ಅಲ್ಲಿ ನೀವು 3 feet ಎನ್ಕ್ರೋಚ್ ಮಾಡಿದೀರಾ ಅಂತ.
ಇದನ್ನ 8 feet ಅಲ್ಲಿ ಎಂಟು ತೀರ್ಮಾನಿಸಿರ್ತದೆ. ಅದರಂತೆ ತಾವು ಸ್ಥಳಾಭ್ಯಾಸ ಸಹಿ ಮಾಡಿದ ಹೆಚ್ಚುವರಿ ಇರುವ 3 ಅಡಿ ಜಾಗವನ್ನು ತೆರವುಗೊಳಿಸುತ್ತದೆ.
ನೀವು 11 feet ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿದೀರಾ, 3 ಅಡಿ ಬಿಟ್ಟಾಗ 8 ಅಡಿ ಆಗತ್ತೆ ಅಂತ.
ಅದೇ 5 feet ಆಗಿರ್ತದೆ.
3 ಅಡಿ ಬಿಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ 8 ಅಡಿ ಆಗಲ್ಲ ಅಲ್ಲಿ. ಹೊಡೆದ ಮೇಲೆ 8 ಅಡಿ ಉಳಿಸಿಕೊಂಡು ಅಂತೆ.
8 ಅಡಿ.
ನೀವು 8 ಅಡಿ ಅಲ್ಲ 5 ಅಡಿ ಅಂತ ಇದ್ದೀರಾ. 8 feet is the cart track.
Difference ಎಷ್ಟು ಬಿಟ್ರೆ ಆಮೇಲೆ
8 feet is the width of a cart track. So any gully will have to be 8 feet.
3 ಅಡಿ ಎನ್ಕ್ರೋಚ್ ಮಾಡಿದ್ರೆ 5 ಅಡಿ ಆಗಿದೆ ಅಂತ ಅರ್ಥ.
So any gully which was done was for a cart track to go in, and that was the measurement of 8 feet.
8 feet.
So 8 feet would set ನೋಡ್ತಾ ಇದ್ದಾರೆ ಅಲ್ಲಿ. ನಿಮ್ಮ ಪ್ರಕಾರ 5 ಅಡಿ ಇರಬಹುದು.
ಆಗಿದೆ ಇದೆ ಗೊತ್ತಿಲ್ಲ. This property.
Where is the photograph? ಮಧ್ಯಾಹ್ನದೊಳಗೆ ತೋರಿಸ್ತೀರ ನೋಡಿ. ಪಾಸ್ವರ್ಡ್ ವಾಟ್ಸ್ಆಪ್ ಅಲ್ಲಿ ಬರಕ್ಕೆ ಎಷ್ಟೊತ್ತಾಗುತ್ತೆ? ಪಾಸ್ವರ್ಡ್
41. 15 meters.
AGA AV ಗಂಗಾಧರಪ್ಪ ಶಿವಮೊಗ್ಗ 53 na 53 AGA for respond number 1 AV ಗಂಗಾಧರಪ್ಪ ಶಿವಮೊಗ್ಗ. Yes.
Number 43.
Yes, madam. Yes.
I am the one separate petitioner with respect to the same property, the same set of grievances, and with the same action connected to the same act, with any property matter. Already there are 2 other petitions who have filed the writ petition before this honorable court and has been partly heard, and there is an interim stay already operating.
Which are those matters?
6856.
Where is the interim order?
In the WP number 6856 of 22.
Where is the copy of the order?
Copy.
You should at least produce copy of the order. 68.
6856 of 22.
Raymond Kumar accepts notice for respond number 1 to 3. Enemy property ಅಲ್ಲಿ ಯಾರ ಅಪೇರ್ ಆಗ್ತಾ ಇದೆ ಕಾರ್ಪೊರೇಷನ್? Pawan Kumar is directed to accept notice for respond number 4 to 6. 4 to 4 and 5. AGA for respond number 6.
I also stand on the same.
Since you are not giving, we are finding. Enemy property you are appearing, connect. NK Ramesh accept notice for 4 and 5. Mr. Kumar, you should be knowing interim order is there.
No, my lord, already 9 petitions, the third separate petitioner for the same property matter. Because the measurement of the property is.
3 of them own it.
So one
Co-owners,
is 5 years.
co-owners, joint owners, co-owners.
Yes, ma'am. So 6856 is owned by another owner to the extent of 70,148 square feet area.
We are wasting time. You could give you a number.
It is.
You framed a question also. Whether the exercising of powers under the Enemy Property Act, a citizen of the country can be proceeded against merely on account of the vendor of the citizen being an alleged enemy of the state.
Yes. So I am.
Respondents connect the above matter with WP number 6856 of 2023. In view of the interim order passed therein, The respondents are restrained from taking any further proceedings in presence of annexure. Yes.
And P. Next is implement. That is Interim is sort honest.
Yeah, annexure, yes. Till next date of hearing. Connect the above matter with 6856, relist on. Then I did 10-4 with this. 10-4 annual. Relist on 24th November. Objections to be filed in the meanwhile. Counsel for the petitioner to serve 2 sets of the petition along with annexures on the opposite counsels.
44. Publishing.
Yes, madam. How is your construction? How is your construction? Your turn. We'll get your property also inspected. Issue notice to respond number 1. Please. No problem. Cool down. Issue notice to respond number 1, returnable by 24th November. Shri Pawan Kumar accepts notice for respond number 2 to 8. All your officers are here. 2 to 8. Respond number 5 and 8. Madam. 5 and 8 are directed to cause the inspection of the property of the petitioner bearing number 244 PID number 29-1-244 in ward number 29 Basham Road, Arlegudi, Cottonpete, Bengaluru. As also the property of respondent number 1. Which is the property of respondent number 1?
In case 43 and 41.
Property details here. Property details here. What is the address? What is the property number? 39. Where is it? Dalstar number of city survey number of the entire property. What is the municipal number of respond number 1's property?
As page meant for the 4 properties, my lord. In the passage, he started putting on the construction.
So is he owner of one of the property in the passage?
No, my lord, he is not.
Any of them?
I am with the property card in page 30, my lord. It says that the common passage there in the lord. In page 30, 31 and 35.
As also the common passage leading up to the said property. To ascertain if there is any construction being carried thereon, or the ownership details thereof. Inspection to be carried out commencing from 10:30 AM on 31st October 2023. Report to be submitted by 9th November, released on 24th November. If the construction is being carried on without any plan sanction or contrary to the plan sanction, respond number 5 and 8 shall ensure that there is no further construction. Process fee and copies to be furnished by end of day 16, failing which the interim order will stand automatically vacated.
file. In your presence.
Srinivasa? Yes, madam? Yes.
Every year, that is living in the demand of monthly gas bill tax. We have export only in this time. Until to forgive the complaint to the police station also. There are independent some to get to the gas factory let their rapidly partition.
Already an order of this court in his favor. Annexure D.
Now, the third respondent is directly export money without having any license for any permission from the panchayat. Now, what happens is that 1 kilometer is that is accident zone from since 4 years and directly export. In those areas, wherever is the order is not, we are not doing any export to that area. In those areas where the 1 kilometer is left under the party area is coming and putting the road is coming the road. So far as I have given the complaint to the police station and also I have given the video. No action.
And AGA accepts notice to respond number 1, Sarjapura. M. Pradeep is directed to accept notice for respond number 2, issue notice to respond number 3, returnable by 27th November. Respond number 2 is directed to ensure that respond number 3 does not put up any flex board in the event of respond number 2 not having granted any sanction or license in relation thereto. Process fee and copies to be furnished by end of day 16, failing is the interim order can automatically locate. Public road. They are constructing on their property and they have come onto the public. It's a cul-de-sac.
Yes, the cul-de-sac. So they just decided, okay, let me go to the in fact, for clarity, my lords, kindly come to page 62, my lord.
Yes.
In photos, 1 and 2. Site number 1 and 2. Behind the green gate is the private. And I produced their savings, my lord. If you look at their boundary, page 35, my lord. They purchase site 1 and site 2 by 2 savings. And at page 35, their boundary on the north is by 4.
They are facing opposite each other.
They're right next to each other, 1 and 2, not by.
Okay. And this road leads up to the end.
Yes.
So who is opposite them?
Opposite them is the back of some other apartment.
Back.
Back of another apartment.
If Pawan Kumar accept notice for respond number 1 to 3, issue notice to respond number 4 and 5, returnable by 27th November. Respond number 3 is directed to cause the inspection of the property bearing number
Site number 1 and 2.
1 and 2.
Right.
Silver Oak Layout, Puttenaldi, JP Nagar 7th phase, Bangalore 560078. And ascertain if a public road situated in front of the property has been encroached by putting up a gate, preventing other members of public from making use of the said road. Inspection to be carried out commencing from 10:30 AM on 2nd November 2023. Report to be submitted by 10th November. Released on zones. cannot do that right now until the report comes.
Very good. Very good. Okay.
27.
47.
47, my lords, that I represent the petitioner's counsel.
It's returnable by 27. Report by. Yes.
47.
47, I represent the petitioner's counsel, my lords.
Request Pranindra. Yes, please.
The case follows where there is a deviation.
Hmm.
Despite our specific directions from this court, they are wrapping up construction and they are going to occupy the property by next week. My lords, may kindly see a connection D is a, my lords has granted an interim order in that matter, not to put up any construction. In spite of that, they went in a page 49, my lords, that's an connection D. It's the interim order granted by my lords.
Hmm.
Page 56, my lords, in the event of respondent 5 and 6 not permitting the officials of respondent number 1 to 4 to return the premises, respondent number 1 to 4 are entitled to take the assistance of the station house officer of jurisdiction. Please.
I represent the petitioner's counsel in 47.
Yes.
Lords, this is the second round of litigation. If your lordship sees the first of the interim orders, your lordship said first causing an inspection,
Hmm.
which your lordship should get at page 49, which was confirmed by the division bench. Ultimately, a report has been filed, my lords, which your lordship may kindly come to 65, running page 65.
Yes.
The violations were found at page 65, my lords.
Yes.
Lords, after this, the writ petition was disposed of by the learned single judge of this honorable court at page 75, directing my lords subsequent action to be taken. That is, my lords, the confirmation order and further proceedings thereto. At page 75, my lords, it's an order dated 10th of July 2023.
Hmm.
Lords, this order, only one portion of the order was questioned by the petitioner herein by filing a writ appeal, which your lordship should get at page 85. Only to the extent where, my lords, the respondent was being permitted to carry out a construction.
Hmm.
Ultimately, at page 89, para 5,
The confirmation
the
order
undertaking
was
was
to be
given that
passed by 7/8/23.
yes, my lord.
Hmm. Yes.
Lords, after this, the confirmation order also came to be passed, which your lordship should get, my lords, at page 96, Annexure M, 16/8/2023.
Yes.
Lords, in spite of it, he files an appeal. The petitioner files an appeal before the BBMP commissioner.
Hmm.
And though an order of status quo is ordered to be operating, he continues with his construction work, finishing his interiors, which your lordship should get at running page 102, which the commissioner also notices. Running page 102, Annexure Q, my lords. It's an order dated 11th of September 23. The typed copy is at 105.
Hmm. This is complete.
Lords,
Yes.
BBMP itself has written letters to BBM, to the BESCOM, to BWSSB, which your lordship should get at page 106 and 107. Up to 108, even to the police, telling them not to give the water and sanitary construction, not to proceed with the further construction. In spite of it, the respondents 4 and 5 are continuing to finish their interior works. And our, my lords, fear is They will occupy the house immediately now. Now that, my lords, the what is known as the auspicious period will start, in spite of having no occupancy certificate in the house. And in fact, we have said occupancy certificate is required.
Respond number 5 and 6, that even your order, forget our order. Your commissioner's order is violated and you can't implement. Are you so helpless? High Court order antu value illa, nimdadru ilva. Brazenness. And you say we can't do anything.
Lords, we have sought for an interim order that they shall not occupy the premises.
That's a minor issue. To make the state a party. The submission being made in all these cases is that they don't have any authority to stop construction. They only issue notice. And they cannot do anything. So what is the mechanism that the state intends to provide to BBMP to implement its orders? If they go give a complaint to the police, police doesn't act on their complaint. Sometimes, most of the time they don't, sometimes they act. They don't have unparalleled. The BMTF comes under the state unparalleled. How many marshals do you have? You put it on record and put it on record. You can't be blaming the state. Nam powers illa anta ಹೇಳಿ. All your engineers are hand in glove. They don't go on. You stop constructions for that 60 square meters, not these constructions. If the person who is brazenly doing it, continuing the construction, orders are passed not to give the this one, even then it happens. The Savan Kumar accepts notice for respond number 1 to 4. Issue notice to respond number, emergent notice to 5 and 6, returnable by 20th November. The serious allegations which have been made by the counsel, by Sri K. Panindral and senior counsel, appearing for the petitioner, that despite orders under subsection 3 of section 248 having been passed, respond number 5 and 6 have continued with the construction. And despite an order of status quo having been passed in an appeal filed before the Chief Commissioner under section 253, the said order of status quo has been violated, which has been observed by the Chief Commissioner, and the Chief Commissioner having written to the jurisdictional police, BESCOM, and BWSSB, electricity connection and water connection are in the process of being sanctioned. The permanent electricity and permanent water connections are proposed to be sanctioned to a building which has been constructed in violation of the sanction plan, as regards which action has already been taken by the BBMP. On inquiry with Sri Pawan Kumar as to why the authority BBMP has not been able to implement its own orders under subsection 3 of section 248, as also the order of the Chief Commissioner directing status quo. He seeks for and is granted 2 weeks' time, 3 weeks' time to obtain instructions and make a submission. Letters having been written to the BESCOM and BWSP. I have the considered opinion that BESCOM and BWSP would also be required to be brought on record as party respondents in the present matter. Hence,
7
BESCOM
and 8.
is brought on record as respondent number 7. 3, yeah. BESCOM. Ms. Sumana Naganand is directed to accept notice for respondent number 7. BWSP is brought on record as respondent number 8. Shri K.V. Monish Kumar is directed to accept notice for respondent number 8. Counsel for the petitioner to carry out necessary amendment and file amended cost acting. I am of the further considered opinion that the submission of the Urban Development Department would also have to be considered. Insofar as implementation of the orders of this court or the orders under section 248 and 253 are concerned, and how the Urban Development Department proposes to empower the BBMP to do so. Hence, the Principal Secretary, hence the State of Karnataka, represented by the Urban Development Department, in turn represented by the Principal Secretary, is brought on record as respondent number 9. Counsel for the petitioner to carry out necessary amendment and file amended cost item, furnish 2 sets of the petition along with annexures on the aforesaid counsels. An order under subsection 3 of section 248 having already been passed, as also an order of status quo having already been passed. I am of the further opinion that the jurisdiction police would also have to be brought on record to implement the orders passed by the company. ಇದೆಲ್ಲ ನೀವು ಮಾಡಬೇಕಾಗಿತ್ತು, ನಾವು ಮಾಡ್ತಾ ಇದ್ದೀವಿ. There's no purpose in this order. What you have sought for? The jurisdiction police, ಯಾವ police station? Work for the other. Jurisdiction police station. So and so is also required to be brought on record to implement the orders under subsection 3 of section 248, as also the order of the commissioner. The so and so is brought on record as respondent number 9. You are the common action. Learned AG accepts notice for respondent number 9. The respondent number 9 is directed to ensure that there is no further construction on property bearing number.
The scheduled property is given, minutes. Schedule is mentioned.
1989.
Page 20.
Block 1, Banshankari second stage. Block 1, 14th class, Banshankari second stage. The respondent number 7 and 8 are also directed not to issue any permanent electricity, water, or sewerage connection to the aforesaid property till the next date of hearing. Relist on so and so date.
In fact, we have said that they can't occupy without occupancy certificate. Once they occupy, my lord, the problem is they'll start claiming equities.
There is no equities, Mr. Panindra, once there's a violation.
That
is why we made. You have to make all this police and you are instructing counsel that to do all of it, which we have done.
Please.
Status quo order would include not to construct it.
Lords, having found, my lords, violations, there can't be any.
Are you so Are you so helpless?
Obliged.
Process fee and copies to be furnished by end of day 16. Failing which the interim order will stand automatically vacated. Early, 2 copies.
48. Justice Prakash.
Page 39, this is the notification issue, in 2009. They have, the board has not rejected their application, still it is pending. But now, they want to allow the sites they remind, on the last page 83. But they have a page 83 and section 2. But 218 sites were allowed to journalists. Already in the page 83.
Hearings.
First, not this is painting company not this notification 2009. But there is no such reservation. Notification under which serial number 18.
So your contention is journalists cannot be given a preference.
I am not
What is
saying
your
they
condition?
should not be given, but our application in 2009. They have not allotted sites to us.
See, this is a notification call for journalists to apply.
Yes,
This is only for them.
yes.
Whenever there is any notification which is, what is your contention?
The must continue. I will answer this page 59.
Yes.
Page 59.
What is earlier notification?
No, 341 sites were reserved.
Yes.
Not being allotted to the journalists. There is a condition. You want to the news notification, 341 new notification. ಈಗಾಗಲೇ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವ ಪತ್ರಕರ್ತರು ಮಾತ್ರ ಹಂಚಿಕೆ ಅರ್ಹರಿರುತ್ತಾರೆ. ಉಳಿದ ನಿವೇಶನಗಳು ಸಾರ್ವಜನಿಕ ಹಂಚಿಕೆ.
What is this layout? Which layout is this?
The same layout. But this is this notification issue inviting application or allotment in respect of Sobin Papa extension. But this was issued in 2009. All the petitioners had applied within the date period. In 2009 itself, they are waiting for more than 15 years.
You are also a journalist.
Yes. In the same layout, the election queue, by the revised layout, they say that some other sites were available. That also they want to allot it to them. Your Russian kindly say, I have obtained.
Are you a journalist or are you not?
I am not.
You are not, you are the advocate. So you are aggrieved by further
Yes, that's the my grievance.
85 sites, Allah.
85 sites. But in fact, when I applied for the information from the board, page 81, this is the petitioner applied under Right to Information Act. I wanted to know how many sites are not remind or not as of 22nd July 2023, page 82. They said 68 sites and houses are available. Page 82.
Yes.
Yeah.
EWS, a lot of the petitioners or some of the petitioners are applied under EWS, economically weaker section. And the lot LIG 43. About 68. And now in two they say 87 cents, 85 cents. Even that 85, they wanted to not, they want to give it to general.
The AGA accepts notice for respond number 1. PHB. HR Pradeep Kumar is director accept notice for respond number 2 to 4. Respond number 2 to 4 are restrained from allotting the 85 sites demarcated in the public notice dated 23/9/2022 at Annexure Q till the next date of hearing. Released on 24th November. Seventy-two. Basement. 72 will reach very soon. 70. After vacation. Learned counsel for the petitioner has submitted that she has served the copies on the counsel for respond who seek for and are granted 3 weeks time to file the respective statement of objections. Objections, if any, by 24th November, released on 28th November.
69 may not. From the other side, may not, he is required to file objection. Objection is not filed after vacation.
69. Learned counsel for respond number 1 and 2 seeks for and is granted 3 weeks.
Petition, I will petition.
Our objections time put. Objections, if any, by 24th, released on 28th. Yes, madam. You are here, we can't help you on. We'll adjourn it, which is the same. Line or birthday? 70? 57. Yes. Here for respond number 6. This is as regarded Udupi. Sorry, Stringeri. Banana chips. 57 at the request of counsel for the petitioner released on 9th November. Serial number? Serial number 4. At the request of the counsel for the petitioner released on 24th November.
ಯಾರು ಅಲ್ಲ ಯಾರು ಕೊಟ್ಟು ಅದಕ್ಕೆ ಸೇರ್ ಬಗ್ಗೆ ವ್ಯಕ್ತಿಗೆ ಯಾರು ಕೊಡಲ್ಲ ಕೊಡಲ್ಲ ನನಗೆ ಕೊಡಲ್ಲ ಅವ್ರಿಗೆ ಉಳಿಸ್ಕೊಂಡು ಹೋದ್ರೆ ಯಾರೋ ಕೊಟ್ಟಿರೋದು
ಟಿವಿಗೆ ರೆಡಿ ಮಾಡಿದ್ದೀನಿ.
ಬೇಕಂತ ಏನಾದ್ರು
ಏನು ಅದೇ ನಾನೇ
ಏನು ಬೇಡ
ಚೇರು
ಇದೆಯಾ?
ಇದು ಅದೇ ನಾನೇ ಎಲ್ಲ ಅಲ್ಲಿಂದ ತಂದು
ಏನು ಬೇಡ ಅನೌನ್ಸ್ಮೆಂಟ್ ಅಷ್ಟೇ.
ರೇಟಿಂಗ್ ಒಂದು ಕಾರ್ಡು
ಏನು ಬೇಡ
ಅಲ್ಲೆಲ್ಲ ಇಟ್ಟಿದ್ದೀನಿ ಮೇಡಮ್.
ಪೆನ್ ಒಂದಿದ್ರೆ ಸಾಕು,
ಪೆನ್ ಇದನ್ನ ತಗೊಂಡು
ತಗೊಂಡೋಗಿ ತೆಗೋ ಅಷ್ಟೇ, ಏನು ಬೇಡ. ಅದು ಬರೀ ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ ಅಷ್ಟೇ. ಸೈನ್ ಒಂದು ಮಾಡ್ತಾರೆ.
ಮೇಡಮ್
ಬರದ್ ನೋಡಿ ಒಂದ್ಸಲ. ಎಸಿ ಆಗ್ತೀವಲ್ಲ ಒಂದೊಂದ್ ಗಟ್ಟಿ ಆಗ್ಬೇಕು. ಅಲ್ಲಿದೆ ಒಂದಷ್ಟು. ಇದು ಎತ್ತಿಟ್ಕೊಂಡಿದ್ದೀರಲ್ವಾ? ಇನ್ನೊಂದು ಎರಡು ಆಗಿಲ್ಲ. ಈಗಲೇ ಹೋಗ್ತಾ ಇದ್ದೀರಾ? ಈಗಲೇ ಹೋಗ್ತಾ ಇದ್ದೀರಾ? ಬರ್ತಾರೆ, ಇಲ್ಲೇ ಬರ್ತಾರೆ. 10 ತಾನೆ ಮುಂದೆ ಮಾಡಿದ್ಮೇಲೆ ಫೈಲು
ನಾಳೆ ಕಂಟ್ರೋಲ್ ಆಗ್ತದೆ.
ಅದ ಸೈನ್ ಮಾಡಿದ್ರೆ ಇವತ್ತೇ ರೆಡಿನೂ ಆಗುತ್ತೆ. ಇವತ್ತೇನು ರೆಡಿ ಅದೊಂದು ಬರ್ಮೇಲೆ ಹೋಗ್ತಾರೆ.
Hello, court officer. ಅದೇನಿದು ಆ ಕಡೆ ಹಾಕ್ತೀನಿ ಆ ಕಡೆ
ಮ್ಯೂಟ್ ಮಾಡ್ರಿ ಮ್ಯೂಟ್ ಮಾಡ್ರಿ
ಎರಡು ಓಪನ್ ವಿಡಿಯೋ ಆಡಿಯೋ
ಎರಡು
ಬಂದ್ ಮಾಡಿ
ಆಡಿಯೋ ಬಂದ್ ಮಾಡಿ
Big order now. Order is
Court officer. On ಮಾಡಿಲ್ಲ ನೋಡ್ರಿ court officer ಕಾಣ್ತಾರೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇವರು ಗವರ್ಮೆಂಟ್
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇಲ್ಲ.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಪ್ರಯತ್ನ ಮಾಡ್ಬಿಟ್ಟು ಏನು ಮಗಳ ಮಾಡಿದ್ರಿ ಬದನಾಯ್ತು ಇದ್ರಾಗ ಸಾವಿರ ಕಾಣುದಿಲ್ಲ ಅದ.
ಇದು
ನಮ್ದಿಲ್ಲ.
ನಾವು
ಎಲ್ಲಿದ್ದೀವಿ
ಬಾಕಿ ಅಡ್ವೊಕೇಟ್ಸ್ ಒಬ್ರು ಲಾಗಿನ್ ಶೀಲ ಅಂತ ಲಾಗಿನ್
ಇಡ್ಬೋದು.
ಆಡಿಯೋ ತೆಗಿ.
Pending for conversion, voice conversion.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಮೇಡಮ್ ಹೇಳಿ.
ಸರ್ ಇದು ಸೂರಜ್ ಗೋವಿಂದ ರಾಜು ಸಾಹೇಬ್ರದಲ್ಲ ಕೋರ್ಟ್ ಹಾಲ್?
ಹೌದು.
ಎಸ್ ಸರ್. ಇದು ಧಾರವಾಡ ಲಿಸ್ಟ್ ಇದೆಯಲ್ಲ ಸರ್?
ಧಾರವಾಡ 1 ಮೀಟರ್ ಇರ್ಬೇಕಲ್ಲ?
ಹೌದು ಅದರಲ್ಲೇ
ಬೆಂಚಿಗೆ ಹೋಗಿದ್ದಾರೆ, ಬರ್ತಾರೆ 10 ನಿಮಿಷ, 1/4 ಗಂಟೆ.
ಹೆಂಗ್ ಆಫ್ ಮಾಡ್ಬೇಕ್ರಿ ಈಗ? ಇದೇನ್ ಸಬ್ಸ್ಕ್ರಿಪ್ಷನ್ ಇದು ಬಂದ್ಬಿಡ್ತೈತಿ, ಇದನ್ನ ಆಫ್ ಮಾಡ್ಬೇಕಲ್ಲ. ಹೆಂಗ್ ಹೋಗ್ಬಿಡ್ತ ಅದ್ ಮಾಡೋದ್ ಬೇಡ, ಇದ್ ಮಾಡಿದ್ರೆ ಮತ್ತೆ ಅದು ಮತ್ತೆ ಅದು ಇದು ಇದು ಹೋಗ್ಬೇಕು ಬೇರೆ ಇದು ತೆಗಿಬೇಕು.
ಇಲ್ಲ ಸ್ವಲ್ಪ
ಅದ ಒಮ್ಮೆ ಬರ್ತೈತಿ, ಒಮ್ಮೆ ಲಗುನ ಬರುದಿಲ್ಲ. ಅಂದ್ರೆ ಇನ್ನೊಂದು ಡಿವಿಷನ್ ಅದನ್ನ ಓಪನ್ ಮಾಡಿದ್ರೆ ಆಗ್ತೀವಿ ಏನಪ್ಪ ಅಂತ ಬೇರೆ. ಕಾರು ಎಷ್ಟು ಬೇಜವಾಬ್ದಾರಿ ಅದ. ಅದು ಅವ್ನ ಮ್ಯಾಟ್ರ್ ಇದು ಆಫೀಸಿಯಲಿ ಇದು ಬರಾಗಿಲ್ಲ, ಅನ್ಆಫೀಸಿಯಲಿ ಅಟೆಂಡ್ ಮಾಡಕ್ತಿಲ್ಲ. ನಾವು ಆಫೀಸಿಯಲ್ ಇಲ್ಲ, ನಮ್ದು ರಿವ್ಯೂದಾಗ ಅಟ್ಯಾಕ್ ಬರ್ಬಿಟ್ರಿ ನಾವು. ಹಲೋ मैं इधर ऑफिस में
ಅಲ್ಲ ಅದು
Last row, sir.
ಕೆಲವು ಮಾಡಿದ್ರೆ ಅಂತ ಕೇಳಿದೆ.
ಧಾರವಾಡದ
My lord, I represent Karvi. He's not in station.
Yes, please.
It is.
Plus, I'm sorry, my lord, I'm sorry. Extremely sorry. Plus, when Karvi is asked, he said he is not ready to pay the amount. He wants time, he don't want to
I have not yet made any
he don't want to pay the amount. It is exactly what Karvi said. I'm
One-
extremely sorry.
ಒಂದ್ ನಿಮಿಷ still ಒಂದ್ ಇನ್ನ ಸಬ್ಮಿಷನ್ ಬಂದಿಲ್ಲ. ಲೆಟ್ ದ ಸಬ್ಮಿಷನ್ ಕಮ್. ಎಲ್ಲಿ ಓಡೋಗ್ಬೇಕು ನೀವು? ಎಸ್ ಪ್ಲೀಸ್.
But unfortunately, Karvi ಇಲ್ಲ, ಬೇತುರ್ಮಟ್ಟು ಇಲ್ಲ, so it is burden is on me. ಅಷ್ಟು ದುಡ್ಡು ಅವ್ನು ಕೊಡಕ್ ಆಗಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾನೆ ಸರ್. 75,000 was insisted by the landlords. That much I cannot pay. ಇನ್ನೊಂದು 15 ದಿವಸದಲ್ಲಿ ಬಿಟ್ಟು ಕೊಟ್ಟು ಹೋಗ್ಬಿಡ್ತೇನೆ ಅಂತ.
Plus, I'm sorry.
15 ದಿನದಲ್ಲಿ ಬಿಟ್ಕೊಟ್ಟು ಹೋಗ್ತಾ ಇದಾರಲ್ಲ.
They are playing with the court. Already 1 month is lapsed now.
We'll now fix 31st and let him vacate ಅಷ್ಟೇ.
31st, my lord.
ಪ್ಯಾಕ್ ಮಾಡಕ್ಕೂ ಒಂದ್ 10 ದಿನ ಆಗೈತಲ್ಲ ಮಿಶಿಲ್.
ಆಯ್ತು but he has to vacate the premises on 31st, my lord. So otherwise, plus the lordship can put some condition because he's. Please.
We'll put that condition of 75,000 if he doesn't vacate. Even from when did their date expire?
22nd September.
So from 22nd September, you will be liable to pay 75,000 rupees per month if you don't vacate by 31st
of October.
October.
That much order may.
No, let him pay the same rent, but he should vacate the premises on 31st of this month, my lord, sir. No, the enhancement of rent also.
If he doesn't vacate by 31st, we are safeguarding it.
His apprehension is that again I may postpone it by paying 75,000. It will not happen.
Learned counsel for the petitioner, upon instructions, today submit that the petitioner is unable to make payment of a sum of rupees 75,000 per month as submitted yesterday. Under the petitioner, would not press IA-1 of 2023 and would vacate the premises by 31st October 2023. Shri V.M. Shelvan, learned counsel for the respondent, opposes the said submission on the ground that the date for vacating the premises having expired on 22/9/2022. 23, the petitioner continues to be in unauthorized occupation, causing harm, loss, and injury to the respondent. Taking into consideration the broad conspectus of the matter, I am in the considered opinion that interest of justice would be served if the petitioner is granted 15 days time to vacate the premises, which shall be so done on or before 31/10/2023. It being made clear that no further extension would be granted, and in the event of the petitioner failing to vacate the premises by 31/10/2023, apart from the petitioner being liable for contempt, the petitioner would also be liable to make payment of a sum of rupees, the differential in the rental to a sum of rupees 75,000 till the date the differential of the rent being paid and 75,000 rupees per month till the petitioner vacates the premises.
From 22nd September.
From 22nd September. From 22nd.
Yes.
Released on 2nd November to report compliance.
Obliged.
Grateful.
Passport matters. Serial number 11. To number.
Yes, Mr. Bhatt. ನೀವಿಬ್ರು ಮಾತಾಡ್ಕೊಳ್ಬೇಕಾಯ್ತು. Spoken to each other. ಬೆಳಿಗ್ಗೆ ಹೇಳಿದ್ರು your colleague sought for a password because you are not there. That satisfies you for now.
Yes.
You won't do any construction.
One more page number 114, there is an endorsement. There is an endorsement that 555/2, this endorsement came to issue in the year 1999. 555/2, ಭೌತಿಕವಾಗಿ ಲಭ್ಯವಿಲ್ಲದ ಕಾರಣ ಬದಲಿಯಾಗಿ ಮಂಜೂರು ಮಾಡಲಾಗಿದೆ. Earlier, this site was allotted in favor of Ms. Mohan. Thereafter, since on verification they found that no such site was available. Therefore, alternative site was available and he has sold that alternative site also. Now, very same site has been allotted.
You want to argue the matter on merits now? Why are you arguing this, Mr. Bhatt now? They'll answer it.
Yes.
Today, the property has to be preserved in status quo. Mr. Ravi is saying that it won't be disturbed. That is what we want. Earlier part is okay. The last part is what we want.
Projects are monitoring not the digitalization of entire parts, 90 not the case management system. That also we are doing in-house case management litigation. We are doing that.
So this will also be part of it. See, this is happening because there is no system. If you set up a system that the Ravi Learning Senior Counsel submits that respond number 13 will not put up any construction or change the nature of the property. His submission is placed on record. The TP Vivekananda Learned Counsel for respond number 2 and 3 has filed an affidavit of the Commissioner of the Mysore Urban Development Authority.
And then every matter for this to direct the learned counsel to take notice. Here in this matter, is court notice was issued. It was received by respective officers. And they did not
This is a
inform the
22 matter.
22 matters. They have not informed the legal section for encroachment of the legal the last. Paragraph number 7, number 8.
Wherein it is stated that due to certain miscommunication, the Wakalatnama could not be furnished to the council to enable him to appear in the matter. Inasmuch as the concerned section was under the belief that the copies of the petition had been sent for instruction and that Wakalatnama had already been issued by a different section. It is further stated that in pursuance of the order of this court in WP number 17737 of 2022, necessary steps for digitization and computerization of the office of the MUDA has been taken up to introduce in-house case management system, and this aspect would also be considered in the said case management system. The said affidavit filed by respond number 2 is accepted. Relist on objections alla file madidira Mr. Vic? Yav ಮಾಡ್ತೀರಾ? On behalf of the council for respond number 13, 3 weeks time is sought for to file the statement of objection. Statement of objection, if any, to be filed on or before 17th November 2023, failing it should be taken as not filed. Relist on 24th November. Needless to say, MUDA would also have to file its objection by then. Matru bidalla. But ಹಾಕಕ್ ಮುಂಚೆ ಅವರು ಬಿಟ್ಟು ಹಾಕಿ.
Man is fighting safely. Good of people did not exist 45 years ago. Therefore, I mean,
the mistakes, if it happens in bona fide, rectify it and go ahead. Mala fide will deal with it. Is bona fide mistake, resolve it. If not, then let us know what is to be done. Both their interests have to be protected. The Gunjal. None appears, no fault twice, relist on 21st November. This blue building is yours. Blue building is yours. ಆಯ್ತು ಬಟ್ ಬ್ಲೂ ಬಿಲ್ಡಿಂಗ್ ನಿಮ್ತಾನೆ. When will you remove this? 3 feet. It's an access, Mr. Ravi. People have to have access. ಗಲ್ಲಿ ಹಳೆ ಟೈಮ್ ಗಲ್ಲಿ ಇರೋದು 8 ಅಡಿ ಕಾಟ್ ಟ್ರ್ಯಾಕ್ ಬಂಡಿ ಜಾಡೋದು ಎಷ್ಟಿರತ್ತೋ ಅಷ್ಟಿತ್ತು. ದಟ್ ಇಸ್ ದಿ ಮೆಜರ್ಮೆಂಟ್ ಆಫ್ ದಿ ಗಲ್ಲಿ. We'll cause an inspection. Records you won't have even to show your ownership on. We'll get that inspection done. Once the inspection is done, then whatever has to be demolished will have to be demolished. Nagmanga Telecast, Mandya. The MS Devraju is directed to accept notice for respond number 1 and 2. Respond number 1 is directed to cause inspection of the property bearing Janjar number 114 bar A1, A2 and A3, na?
Yes.
A1, A2 and A3
And also the adjacent road.
to ascertain their respective measurement. As also the adjacent road on the western side of the property measure the same to indicate and submit a report indicating the width thereof from the place the said road starts to the place that it ends. Namely the width at different places. The inspection to be carried out. Inspection measurement to be carried out commencing from 10:30 AM on 31st October 2023. Report to be submitted by 10th November. Relist on 17th November. Until then, the respondents are restrained from in any manner demolishing any portion of the property of the petitioner. Copies to be served. Standing counsel by end of day 16, failing with the interim order will stand automatically vacated. You have to carry out inspection measure. Nodi the order note to get it.
230 matters, either number 73.
I am for the respondent, my lords.
Jagdish?
My lords.
Yes, sir, Jagdish.
I am for the respondent, my lord.
Yes. ನಿಮ್ಮ ಹೆಸರಲ್ಲಿ ಅರ್ಧ ಹೆಸರು ಇದ್ದಾರೆ.
ಹೌದು ಸರ್.
Yes.
Is not housing board secretary is not the required before this court, my lord, to adjudicate the matter, because we have taken action against him for having violated the sanction plan and for having put up construction, and the report is before this court, my lord, to show
submission you want.
Yes.
You have 3 adjournments for this after the report has come. We don't need the housing board for this. Why do you need the housing board? If you have a claim against housing board, you proceed. Here we are dealing with the construction which has been put up illegally, contrary to the building bylaws, to the extent of 300%. If you want to make your submission, please make your submission. Yes. Yes. You have taken a lot of adjournment, Mr. Jagdish. We won't give you. If then we are dismissing the matter. You are taking the court for a ride. You have been told thrice, argue. You are not arguing. You request madri, nim request ge, we have given you that adjournment. It was fixed today at 2:30 for you to argue. It's your choice. Last time we are asking you, if you want to argue, you can argue. Despite three adjournments have been granted to the petitioner, and the matter having been fixed today, finally for arguments. Today also, the learned counsel for the petitioner seeks for an adjournment. In that view of the matter, I am of the considered opinion that the petitioner is not interested in prosecuting the matter. The petition is dismissed for non-prosecution. Agoitu pending IA stand dismissed. Next though. 74. What are the submission, Mr. Reddy? Yes.
Steps taken by the Chief Commissioner.
All of them are valid. All of them are valid suggestions. This should be done. Copy ಕೊಟ್ಬಿಡಿ. ಇದು ಕೊಟ್ಟಿದ್ದೀರಾ ಅವ್ರಿಗೆ? This memo you have given a copy? AGA one copy ಮಾಡಿ ಕೊಡಿ. The AGA will not. They have implemented the Khata in the BBMP, but there are several defects or several lacunae. Defects and lacunae. These lacunae need to be rectified. Counsel for respondent number 1 and 2 has filed a memo enclosing a letter addressed by the Chief Commissioner BBMP to the Secretary E-Governance, bringing to the attention of the Secretary certain lacunae in the E-Khata services, and the Chief Commissioner has requested for those lacunae to be addressed. A copy thereof is also now furnished to the learned AGA with the direction to furnish the same to the Secretary E-Governance and obtain instructions. Relist on 22nd November. Objection. Yes, madam. Yes. Hmm.
Or any other main reasons of the petition seems to be that there has been a cap certificate given by the trustee on which the candidate who has been elected as a member of Gram Panchayat under a general category, he is now enjoying the post of Objection, which is reserved for DCP category.
Now, in between there are two lines. After being elected as a under general category, the respondent has got a certificate showing that she belongs to the BCM B category. And since it is really reserved for B category, she has contested as a B category and won the election. Having been elected as a general category, yeah. Yes. Hmm. Yeah.
Belonging to backward classes, but number of seats for reserved backward classes under this substitution so determined that the total number of seats reserved for the scheduled caste and backward classes under this substitution shall not exceed 50% of the total number of seats in the town. Provided that out of seats reserved under this substitution, 80% shall be reserved for and the remaining 20% of the seats shall be reserved for category B, provided if there is no person falling in the category A is available, seats reserved for that category has been held for Gram Panchayat members, and the reservation for Gram Panchayat members is determined under section 5 of the number. Now, my lords, we kindly turn to section 5(8) of the code.
Yes.
The deputy commissioner shall publish in the prescribed manner the members' names of members in the
Hmm. Yes.
Name of petitioner is petitioner has contested category D category and respondent number 6 contesting respondent as contested category. So now, my lords, section 5(8) procedure is already complete. Deputy commissioner has declared for all the members, both under private classes and general category. Now, my lords, we kindly turn to section 44. That is the procedure now we have completed.
Yes.
General or special or special election commission should result. A such objection of Gram Panchayat in the state for the scheduled caste and scheduled tribe, and the number of such offices varying as nearly as may be the same proportion to the total number of offices, as the population of scheduled caste in the state of the scheduled tribe in the state based on the total population of the state, provided no person belonging to the scheduled caste is available. Seats reserved from the category will also be filled by the person belonging to the tribe and vice versa. Such number of offices of objection of Gram Panchayat as nearly 51/3 of total number of offices and Upadhyayasha in the state for the persons belonging to private classes. But the number of offices of objection and Upadhyayasha reserved for private classes and the list lost in the scope determined that the total number of offices in objection and Upadhyayasha reserved for the scheduled caste and scheduled tribe and the clause here for private classes under this clause shall not exceed 50% of the total number of offices of objection and Upadhyayasha of Gram Panchayat in the state. Provided that out of the offices reserved under this clause, 80% of the total number of such offices shall be reserved for persons falling under category A, and the remaining 20% of offices shall be reserved for persons falling under category D. Provided for there is no person falling under category A is available, the offices reserved for that category should also be filled by persons falling under category D vice versa. In this, when I was reading about section 44, my lord, please. Every Gram Panchayat.
Fourth line of
section 44. Every Gram Panchayat shall within 1 month from the date of publication of name elect kindly mark. It does not specify amongst the elected category members, elected amongst all the members, elected members under subsection 8 of 55 or immediately before the expiration of the term of objection. Choose 2 members. Choose 2 members of the Gram Panchayat to be respectively objection. After reading this number to section 45. After reading the members of its constitution, reconstitution or establishment under this act, and in any case, 1 month from the date of publication of the games of the elected member under subsection 8 of 65. Meeting of Gram Panchayat decided over validity of all objection of the under this act that be decided by the they have gone into the designated form. Now, the only question of law and laws we are considering there is whether a person who is selected under a general category can he or she be eligible to contest for a category. You may belong to any category, but you have contested in the general category. So does that restrict you only to represent person? You are eligible otherwise, belonging to a backward class or a scheduled caste or scheduled tribe, elected under the general category. Be permissible to contest for Adhyaksha and to hold this. My respectful submission is this. Allows this honorable court to attain on this decision.
Give them a copy. Give them a copy.
I will. General category, the reserve category, one of the relevant parameters, getting the relevant parameters.
Page. 30. 13 or 30? Yes.
In view, now the question is no more in that is clearly covered by the decision of this court reported in Karnataka. In that case, the appellant they belong to backward class but had been elected to the municipality until the election for the post of the president of the municipality, which was reserved to backward class candidate. The only question that had fallen for consideration in the said case was whether the appellant belonged to the backward class but had been elected to the municipality. For election for the post of president of the municipality was reserved for backward class candidate, or whether the candidate for the post only be a person who is elected to the the participation in the conduct of affairs of the municipality, but it is also an effort to improve their law. The reservation ensures that the specified minimum number of persons belonging to that category becomes members of the municipality. If because of their popularity, a large number of taking cash exercise backward classes or women get elected to the municipality than the number of reserved seats, that would be welcome. When the idea is to promote the legal and improve their law, see a contradiction in terms of the members belonging to that section from standing in the office of the president because such a candidate is popular enough to get elected from the general council. It's a fundamental principle of democratic election. The person who is more popular is elected. Popularity being measured by the number of votes which the person gets. Language of various legal problems do not indicate such as expressly or by necessary implication that even the person who belongs to the reserved category and is popular enough to get elected from the general council should be barred from contesting the election of president and the office is to be filled only by a reserved category person. Because further observed, the act and the rules provide for reservation of scheduled caste. No reservation or classification is made for us. Differently, all members of scheduled caste, for example, will be regarded as belonging to one class, irrespective of the fact whether they had been elected to a reserved seat or a general. With regard to backward class, scheduled tribes and women. The law does not contemplate or provide for any other subqualification classification of the type which has been suggested by the respondent. Just as all members of the municipality, irrespective of the fact they had been elected to a reserved seat or not, are eligible to the post of president when it falls in the general category. Similarly, when as per posters, the president is to be for one who says belong to a category of scheduled caste, then all members of the municipality or scheduled caste have been elected would be eligible to stand for election. Neither the act nor the stipulated only in such a member who has been elected to the reserved seat to be eligible to stand for election before when it is the third category of the candidate to be filed. Furthermore, para 31. Article 240 this court, by examining the two important elements of Article 226 of the Constitution of India, there is no indication of suggestion in Article 240.
Do you have Ganchi's decision? Because you're reading the extracts from, you as well give us that judgment. Para 16. And where the earlier paras, which you read? Your reservation is para 14. Yes. Yes, please.
Must necessarily mean that concern of political committee must have Compartmentalization and non-act that the concept of rotation being that for the context of the president is the ground of members of elected from the seat reserved for that category. This inference is already drawn does not go from the plain language constitution or from the provisions of the act of which they made under, and it also does not promote the objective of reservation of the the legal provision provided that the office of the president municipality go for rotation category and no more. There are the highlight market. The representation of the category is what the office. These provisions do not provide that those members who fall in the category those who have been elected reserved for that category. But reservation with reference to the category caste the person belongs to not the need of in our opinion, therefore, they do not go to
so they differ from Saraswati Devi, which had end up this. This is a full bench. Yes. Yes. Supreme Court I will move it in. Yes. Page. The questions. Questions. Yes. The same question. Ganchi is referred to. On that basis only, Ganchi has been applied. Few of the judgments are, you don't need to burden it. There's so many judgments.
No, but only for one reason, I thought that they have already.
No, that is different. Election petition is different. The apprehension on part of Mr. Gangadharappa is that since the deputy commissioner has given this finding, and if the finding is in his submission, the finding being wrong, the district court may also get influenced by it. Therefore, this court has to intervene to lay this down properly. So now we suffer a double whammy. Not only deputy commissioner, he'll get an order from this court also. You are in a worse position now, Mr. Gangadharappa. So now Mr. Gangadharappa will go and withdraw that election petition. Yes, Gangadharappa, anything you have to say? Here.
Because 243 go
243O. 243T was referred. Now you are referring 243O. This is for Gram Panchayat.
interference by court in electoral matters.
That is there. That has been now
Yes,
watered down also by the Supreme Court. What we held in another matter where the AG appeared has now been upheld by the apex court in that matter. That bar is not a full bar.
In addition to that, here the petitioner is for the Supreme Court by challenging the order of the deputy commissioner, which is in turn related to caste certificate.
We are not dealing with caste certificate. That is a different
No,
body.
that caste certificate itself is a challenge before the honorable deputy commissioner. Subsequently, when it got allowed, subsequently this petition was filed. Even the petitioner has approached before the honorable trial court by filing an election petition, which is both are interrelated. This petition is allowed. Ultimately, the prayer before the election trial court for election petition.
The Additional Advocate General is argued on all these things.
Submission.
They don't narrow it down or water it down now.
My only upon submission. This petition is allowed. Ultimately, the other.
What would we say?
That is
Mr. Gangadharappa.
In one.
Yeah, you are ready
As
with
per the
something.
notification dated 13/1/1995, the election was declared. According to them, I am ineligible candidate as per the notification, said notification. According to them, I have a excess land and I'm paying tax.
In the election petition, not before us.
Even in this petition, which was decided before the honorable deputy commissioner, the same thing was observed in the said petition. I request your lord to take the certificate.
What is before us, you'll have to address to. There are a lot of contention before the election petition. In the election petition, there are a lot of contention before the deputy commissioner. But we are dealing with only one point.
Please.
Whether a person elected in the general category can later on contest in the reserved category for the president. That's all.
It's one citation.
Yes.
State of Karnataka. It is also similar set of facts, except the petition was challenged before the Honorable High Court of Karnataka by the voters. In this matter, page number 3, 4, page number 4. In that matter, the appellate initial challenge.
Council, there is a false certificate which was produced. It's a completely different matter.
My submission, initially she contested the general election.
Who are you appearing for?
Respondent number 6. It is challenged against me.
Lawyer should know when to speak, when not to speak. That's how much we can tell you. Yes, Mr. Gangadharappa.
Type of the act relevant. Action of of member of the Gram Panchayat.
Yes.
Parties have contested general election held in 2020. Based on category then reservation, reservation all categories. Is not the election. Knowing that some of them are elected from election. The time when election was held, the numbers of the they fought the election based on that army certificate that has been issued by the company. Now the rules does not provide, or the act does not provide, as to on what basis a particular person will be considered as a backward class India. Very silent. Now, for that purpose, the authorities of the revenue department will be charged that now, in the instant case, everything has been completed in one day, including the filing of the application and issuance of the certificate. In such a case, after the notification issued by the Petitioner for holding the second term of the objection to Parliament. First term of the objection to Objection was completed, and second term of the objection to Objection for 2.5 years was issued.
Yes.
My submission before this article is to number one, whether a person who has been elected from a particular category in the general election be permitted to change the category from backward class to the vice versa, or general category to scheduled caste and scheduled caste. That is not permissible because once you have contested and chosen as a candidate in a particular category, you will have to stick on to that category only. There is no question of change of category. Otherwise, what happens is the person can go on changing as and when he likes and defeat the very purpose of reservation. Reservation is meant for persons and category of persons to get elected either to the post of Objection and Procedural or as members of the Gram Panchayat. If this is permitted, then there is no end. One person can go on changing. Supposing a person is got elected from general category and the post is reserved for a person belonging to scheduled caste and scheduled trade. He can go on changing, stating that yes, I am entitled to contest.
That is the purpose of reservation, as I said.
That is the purpose of reservation. Reservation, if it is past the category or post. Kindly see section 5. For this purpose, I invite the kind attention on this. Category of post is the reservation and not the person.
Even if you go by section 5,
Sure.
the one member for every 400 population.
Right.
So if the population is, for example, 2,400, 6 seats. 6 seats only. Let's take this as the only example.
Yes.
3 seats will be reserved for SC, ST and BC. Rest 3 are available. So these 3 who have been elected, if they could, even a BCB or a SC, ST could contest in the general category.
Yeah.
And win it.
No, the only difference is this. As the other court found this one, a person can contest irrespective of his category to general category. There cannot be any dispute about it.
Yes.
Supposing more persons contest and at the time of counting, If a person belonging to scheduled caste, scheduled caste gets the highest number of votes, then first he will be declared as elected.
Yes.
Then another person belonging to scheduled caste also gets more number of votes than other candidates, then he will be elected from the general category.
Yes.
Not necessarily that person contesting from general category shall alone be declared as elected.
Yes.
This is what the Supreme Court says. Then in such event, persons who secure highest number of votes, irrespective of the category to which they have been contested, that will not be taken into account in the declaration. Now, for the purpose of reverse a contingency, suppose if a person gets elected from scheduled caste, scheduled caste, there is no ground for him to contest for the general election, general court, in the case of objection and objection. But that is not permissible. So a person who has been elected from general category contest in the election to objection and objection, stating that no, I still belong.
Distinction is if that person belongs to SC/ST category, whether he is elected in general or otherwise, it does not make any difference.
So,
can contest.
section 5.
Yes.
It is permitted to read section 5. That is where the difference.
Which portion of
Section 4.
section 4?
Yes.
Yes.
Not less than 50% of the seats reserved in each category or persons belonging to scheduled caste, scheduled tribes, and backward classes. Under the non-reserved seats in the Gram Panchayat shall, subject to the general or special order of the government, that it is the election commission. Be resolved by the deputy commissioner of government, subject to the moral limit of rounding off to the next number. These are to remain constant to the area and such rotations are yes. Provided further that nothing contained in the statute shall be deemed belonging to the and scheduled and backward classes for whom these shall be reserved in a Gram Panchayat from standing for election to any non-reserved seat in such a Gram Panchayat. Please notice this.
Yes.
I will read it once again. Provided further that nothing contained in this section shall be deemed to prevent a woman or a person belonging to scheduled caste and scheduled tribes or backward classes for whom seats have been reserved in a Gram Panchayat from standing for election to any non-reserved seat in such a Gram Panchayat.
Yes.
Subject to provisions of Section 4 and subject to the general of the government, the deputy commissioner shall be able to determine the confidence into which the area within the jurisdiction of every Gram Panchayat shall be divided for the context, etc. etc. will not be then 6. If for any reason the election to the Gram Panchayat does not result in the election, required number of members are equal to commitment. 7. Notwithstanding anything contained in subsection 1 and 6, but subject to any general or special orders of the government, there total number of members, etc. The deputy commissioner shall publish in the prescribed manner. That is there. Deputy commissioner has published as per annexure 8 names of persons elected from particular category from particular ward or constituency as the case may be. Now, so far as the 6th respondent is concerned, she has been elected as a member from general category. Nothing prevented her from contesting the election from a result and constituency on the note that she belongs to either backward caste India or UP. When she elected and got elected to particular category and got elected by contesting from particular category, she will have to stick on to that category only during the period of 5 years. And there is no question of change of category. Yes. It is not permissible. You have chosen to select that particular category to contest in the election. You got the votes from the voters, got elected to that particular category of the seat only.
We understood your submission.
Yes. Therefore, the period of 5 years is the limit.
Until 5 years, no change can happen with your submission.
Yes.
But the Supreme Court says otherwise.
Yes. Now, the Supreme Court, this is how what the Supreme Court says. In the year, in 2018, 6 Supreme Court cases, page 162.
Yes.
Page 7.1. Paragraph 12. I will read from paragraph 12 at page 170. Returning to the demanded petition of the there must be not the representation and risk for the grant of being paid with the institution including instead of the command. Let us see the data of the example the data. The original document having part of the by email and other data 21 the learned AGA taking for point number 1 by the comment document in income certificate to respond to the party or the of this code. Application of the document.
Yes.
It is clear that on 22/4/2015, respondents have filed application for interest of cash certificate and the cash and income certificate. And 23/4/2015, the jurisdiction revenue inspector has issued notice to the fund finding out the enough to issue the cash and income certificate. On 26/4/2015, the revenue inspector has issued a report recommending the issue cash certificate to the petitioner in backward class 2B. Revenue inspector are conducted other along to play the movement and provide that there is no objection to the cash certificate to the petitioner in backward class 2B. Statement of ceremony party versus also before the revenue inspector going before the ticket for the Banari number revenue area on 26/4/2006. Part of the original notice the rest of the university the entire process of issuance of cash certificate is concluded in 5 days. That is, application was filed on 22/4/2015 and the cash certificate was issued on 26/4/2015, which cannot be said to be clear as intended by the general 2026. However, on perusal of the credit file and after purchase it was and that it is also seen that date 26/4/2015 is overwritten. This creates a serious doubt about the process of details of data in respect of the 25. Respect number 5 is the responsible officer of the department has issued a caste certificate in a model area.
This is the extract of the High Court judgment.
This is the
This is Supreme Court.
Paragraph 19 at page 176.
Hmm.
The moot question in the present case is whether the High Court in the past of the present case was justified in the required jurisdiction to issue a return over. That was adverse to the section made in the report of the wherein the respondent was in man. The relevant paragraph has been identified in paragraph 6 and 7 of the resolution. The case of the resolution was that the appellate in of the bogus and part indicated that is inclined to backward and which was surreptitiously obtained from the respondent. In support of this claim, the purpose of the allegation is that the false, incorrect, and misleading declaration was given by the appellate in respect of the status and income. In fact, in the first affidavit dated 2016, he had declared that he was receiving rate of his contact at the time. The respondent was receiving rate of 4,80,000 per annum. Whereas in the second affidavit dated 26/4/2016, while in support of the application of the Act of Income and Tax Certificate, he has stated that the annual income of the family was only rupees 3,60,000 and that he was required for not paying income tax and commission tax. According to the definition of this declaration was false in the knowledge of the appellant. What of the caste certificate was of the application without any proper information as required by the law. On these assertions, the matter proceeded before the court. We will advert to the explanation offered by the legislator. First, we must notice the other entities which had come on record during the hearing of the legislation and which varied with the High Court. During the hearing, the original official file related to the grant of caste certificate to the applicant was produced by the government administration as notified by the 11th and established in the report above. On analyzing the documents contained in the original, it is noticed that the caste certificate was not granted to the appellant on the same day of the applicant analyzed almost 5 days. Time for processing application and for its 6 years. In that first, a notice was issued by the deputy inspector. Then a report of the deputy inspector was prepared. Other was prepared statement also.
All those things relating to facts, finally you come to 41 and 43. It's being left to the caste verification committee to decide on the validity or otherwise. By about another 9 pages. So if you have any grievance as regards, go before the caste verification committee. If you succeed there, you can use it in the election petition. That liberty will reserve. You already always have, will reserve it.
No, my submission before the stand of is what the Supreme Court in the present judgment says is the certificate issued by the Tahsildar is not enough. It has to be sent to the caste verification committee, which has to verify, and thereafter only caste certificate could be issued.
When there's a doubt raised, yes. You are now raised a doubt. Go before the caste verification committee.
No,
prove otherwise. You are entitled to prove otherwise. If you succeed.
No, the father of proof is on the applicant to make an application.
Even the apex court came to a conclusion that the apex court cannot go through it. In its large power, and it is the caste verification committee which has to do it. Then you can come for quo warranto if you succeed in that.
Yes.
But until then, there is a caste certificate which is there. The question that you had raised on the constitutional aspect of it is whether a person from one category can change to another category, from a higher category to a lower category.
Yes.
Is what your submission was.
That is one aspect. The second aspect is even the Tahsildar to issue a caste certificate.
That we can go into that. You
without sending the papers to the caste verification committee.
That you have to impugn before the caste verification committee. You go there. We cannot do that. That's a factual aspect.
Factual aspect is Tahsildar cannot straightaway issue the caste certificate unless it is recommended by the caste verification committee.
Challenge, Marty. That's a different aspect. We are not concerned with in this matter. That's even the right.
The other question I would like to submit for non-prosecution. Under the Act or use, there is no provision for the Tahsildar to issue a cash certificate. It may be issued for various other purposes.
This is a matter you are arguing in rejoinder. You did not argue in the main. You are arguing in the rejoinder. This is not a matter which can be taken up now on this. Whatever as regard cash certificate that you have, whatever the process that has been followed, verification committee.
That has to be done by the cash verification committee.
You are entitled to agitate that.
And this is what the Supreme Court says.
Para 43.
43.
Yes.
According to the authority, and the relevant physics of the rules will take as a defense which are included in the present of the however dispose of the repression by the responsibility being repression on the also only by directing the cash verification committee to expedite the inquiry regarding the validity of income and cash certificate issued to the appellate to respond on the file and confirm the same preferably but also intimate final decision to the appellate within the same time.
Yes.
So this is also required to the present case. And
Have you approached the cash verification? Have you approached the cash verification committee?
I will approve. I will approve the cash verification.
If you go, we will give an expeditious time.
In no time, I will file the application, there is no difficult data. I will file it and time it is prescribed by the court. So that I will make an application before the cash verification committee.
Yes.
And another aspect which I would like to submit incidentally is, now my contention before the election tribunal is that the acceptance of the nomination paper of the sixth respondent is illegal. Now that has to be decided by the election tribunal. By virtue of this, the person who is not entitled to hold the post of objection will continue. Therefore, two requests I would like to make before the court. Number one is, I will make an application before the cash verification committee and the direction and guidance issue for the committee to
Expeditious.
that is number one. Number two, election tribunal is also effectively directed to dispose of the matter as early as possible. This is
ನೀವು ಅದು ಬರೋವರೆಗೂ ಎಲೆಕ್ಷನ್ ಟ್ರೈಬ್ಯುನಲ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಅದು ಬಂದ ಮೇಲೆ ಇದು.
the second thing which I would like to make is, let not the order of the deputy of the United Party have any influence on the election petition which is filed before the election tribunal.
Petitioner is before this court seeking for the following release. The petitioner claims to be a resident and voter in Lingamnalli village, which is a constituent village of the Kunnala Gram Panchayat, which has 9 wards and 21 duly elected representatives. The petitioner was elected to the said Gram Panchayat from Lingamnalli 1, which is reserved for category B women. One of which seats was reserved for category B women. Respondent number 6 is stated to have been elected from one of the seats in Dodda Kunnala, which was reserved, which is unreserved in the year 2020. In the elections held on 22/12/2020. Elections have been called for the post of Adhyaksha and Upadhyaksha in the year 2023. It is stated that respondent number 6, having obtained a caste certificate showing herself to belong to backward class group B category, contested for the post of Adhyaksha, which had been reserved for backward classes, class B category, group B women. and having succeeded in the said election was returned as a successful candidate. The grievance of the petitioner is twofold. It is assailing the same that the petitioner had approached the deputy commissioner who had, while order dated, who had approached the assistant commissioner who passed an order, who upheld the contention of the petitioner that respondent number 6 could not change a category from general to BCB women, and as such granted an interim order. Challenging the same, respondent number 6 had approached the deputy commissioner. The deputy commissioner initially had stayed the order of the assistant commissioner and permitted respondent number 6 to contest the election. And by the final order dated 9/8/2023, taking into account that the election petition which was filed by the petitioner came to the conclusion that all those matters would have to be decided in the said election petition, but however, had made various observations which lead to an inference that the change in the category was permissible, and it is assailing the same that the petitioner is before this court. Sri A.V. Gangadharappa, learned counsel for the petitioner, would submit that once a member of the Gram Panchayat is elected in the general category, the said member cannot change the category to any reserved category and contest for the post of either the Adhyaksha or the Upadhyaksha, which is reserved for such particular category. The second submission is that there has been gross hurry in issuance of the caste certificate in favor of respondent number 6, which does not inspire any confidence. And without the same having been referred to the caste verification committee, the deputy commissioner could not have on his own come to a conclusion that the candidature of respondent number 6 in the reserved category was permissible. In this regard, he relies upon Section 5 of the Gram Swaraj and Panchayat Raj Act 1993 to contend that the reservation of seats having been categorically prescribed and the election having occurred in terms thereof, subsequently the returned candidate cannot change his candidature. He also relies upon the decision of the Apex Court in 2018, 6 SCC 162, more particularly para 41 and 43 thereof, which are reproduced hereunder for easy reference. Ms. Pratima Onnapura, learned Additional Advocate General, rebuts the arguments of the counsel for the petitioner by relying on Section 5 and Section 44 of the Gram Swaraj Act. Her contention is that the reservation under Section 5 is for the election to the Gram Panchayat, whereas there is a separate reservation provided under Section 44 for the post of Adhyaksha and Upadhyaksha. The manner and methodology of such reservation under both the clauses, both the sections being different, the reservation in the first under Section 5 for election to the Panchayat cannot be made applicable for candidature and or election to the post of Adhyaksha and Upadhyaksha. In this regard, she relies upon the decision of the Honorable Apex Court in 1997 Supplementary SCCR 401, more particularly para 14, 16 and 18 thereof. And a decision of this court, the coordinate bench of this court, in ILR 1998 Karnataka 4019, more particularly para 2, 6, and unnumbered para 3 at page 4025, which are reproduced hereunder for easy reference. By relying on both the above decisions, she submits that the decision of the Honorable Apex Court in Ganchi's case was applied by a coordinate bench of this court in Ramappa's case. And the proposition laid out in both the matters was that a person who is elected for a particular category to a panchayat, to a municipal corporation, could contest for a reserved category, and there is no embargo on the same, since it is the avowed intention of reservation that as much opportunity as is available be provided for a person of the reserved category to be uplifted and contest in those elections. Right, counsel for, what's your name? See? Birth certificate. So and so adopts the submission of learned additional advocate general and submits that the petition is required to be dismissed. Heard Shri A.V. Gangadharappa, learned counsel for the petitioner, Ms. Pratima Annapura, learned additional advocate general for respond number 1 to 4. Sorry, respond number 1 to 4, and it is so and so for respond number 5. Peruse papers. The points that would arise for determination are: 1, whether a person who is elected in a general category to a Gram Panchayat can at a later point of time contest for the post of Adhyaksha or Upadhyaksha in a reserved category. What order? Ali, counsel for respond number 4. Ali, he adopts the submission of learned counsel for learned additional advocate general. He additionally submits that in the present case, the election relating to Gram Panchayat should be Article 243O, which would apply, and as such, this court ought not to intercede in election matter when the matter is seized by in the election petition. So, it's also dictated the facts, contention, and points for consideration dictated in open court reserved for judgment. The argument was 414 ಆಗೋದಿಲ್ಲ ನೋಡ್ಲಿ. Mr. Anil Kumar, what is the status? Respond number 5. Respond number 5. Your prayer, you asked for respond number 5. You made us put pressure on him. Madam, learned counsel for respond number 6 and 7 has filed as statement of objection. After service thereof of the counsel for the petition, same is taken on record. Madam, respond number 5, new AGA. 5. The prayer is against 5. Prayer nim mel kelbit our mel allegation. And AGS seeks fund is granted 2 weeks time to obtain instruction and make a submission. Relist on 9th November.
But as part of allocation of the job card holder as well as paid to technician under Narega scheme, the second respondent.
Yes.
And is also a member of Jilla Panchayat. And it shares C and D discloses that it is was a certificate in the dispatch form. And it, my God, he was also awarded road wages in Gap and College to take care of these two jobs. Now, my God, subsequently the first respondent is issued a communication saying that the person cannot be continued in 2 ways also. Either he has to choose to be a member of a Gram Panchayat or he should be a paid technician. That has been challenged before this court, my lord, and we have also to notice and issued a interim order of state, which are composed of annexure H. Two matters are already admitted.
Yes.
Annexure H is the petition number 17,497. Same issue just to be swapped along with the resolution. In fact, the second
Yes, we remember.
Yes.
This is not an office of profit. The CGP accepts notice for respondent number 1 and 2. KR Patel. MS Devraj is directed to accept notice for respondent number 3. The order dated 3/8/2023 in so and so issued by second respondent at Nature A and official memorandum dated 39/2023 in so and so at Annexure B is stayed till the next date of hearing. Connect the above matter with WP number 17497 of 2023 and relist on when is that matter? Yavatida the 174. Yeah, 7. Adadmele next week and Jadu Barala. Wait for it. He lists on so and so. Madam, you will have to file your objections in these matters. Notice Sarvagilva. The Pawan Kumar accepts notice for respondent number 1 to 4. The contention of the counsel for the petitioner is that without issuing notices under section 248(1) and 2, a confirmatory order under 248(3) has been passed. In that view of the matter, the confirmatory order at under 248(3) at Annexure F is stayed till the next date of hearing. The counsel for respondents is directed to produce the original file to indicate whether the
From the petitioners. Result for Australia scheme for past 20 years and page number 35 annexure B.
for the past 30 years.
20, more than 20 years. The inspection also has been made by the AC and has given a report in 62.
62.
Stating that the residents of these sites have already been issued Aadhaar to the BMTA and everything and
Then the CGP access notice for respondent number 1 to 4, Mysore ZP. Vijay Somayaji for 5 to 6, 5 to 7, Chamundeshwari. Sumana Nagnan for respondent number 8. Respondent number 2 to 7 are directed not to disposes the petitioners till the next date of hearing. We list on 24th November.
The order was produced taking for 1
Hmm.
by the assistant director town planning.
Yes.
Contravention to 242 was
Now it is state. We are a little late. You are 1 day late. It has been stayed by the division bench. Now you challenged in 253.
Irrespective of that, my submission before my loss. The provisional order was as well as confirmation order passed without conducting any inspection.
That you can raise under 253. Not before this.
253, because we approached the chief commissioner and wanted to find the appeal. We informed that this second sitting is only on 21st. My demolition is on 18th. I do not
Have you filed an appeal or have you?
They have not filed appeal.
When will you file? Tomorrow? Monday?
A week's time maybe.
You gone and they told you that and then Monday file madak ready irಬೇಕು.
Saturday we required.
So you did not go to file inquiry matter.
A week's accommodation will be given, protection will be given, will file the appeal.
Petitioner is before this court seeking for the following reliefs. The orders which are under challenge are under section 248, 1, 2 and 3 of the BBMP Act 2022. The conditional counsel for the petitioner is that a demolition order having been issued under section 356 as per annexure B, the sitting of the chief commissioner, who is the appellate authority under section 253, he is now scheduled to be held only on
Likely to be scheduled on 21st.
on 21st October, and as such, interim protection is required. He further submits that the petitioner is ready to file an appeal under section 253 and given a week's time, the appeal would be filed. In that view of the matter, granting liberty to the petitioner to file an appeal, which shall be filed on or before 20th October 2023. 21st is Saturday. Sitting. On or before, when you file it on or before 19. On or before 19 October, the operation of the demolition order at annexure B dated 19/6/2023 is stayed till the next sitting of the chief commissioner when the matter of the petitioner is directed to be taken up. Owning IAS stands disposed.
The IAS.
Yes. Same 248 1 and 2. 248 3. Sorry, 248 3 Agila. Reply to it.
We have submitted an alternate investigation and he's got to.
You have submitted your reply.
Already I have one and showed it.
Not orally, in writing. There's nothing oral in government department. This 248.3 has not been passed. You submit your reply. When will you submit your reply? Petitioner is before this court seeking for the following reliefs. The petitioner is before this court challenging the provisional order under the notice and provisional order under section 248 1 and 2. Submission of the counsel for the petitioner is that oral reply has been given, so also documents furnished. Being of the opinion that the same is not sufficient and that the petitioner would have to submit his written reply, which shall be so submitted on or before 20th October and considered by the respondents thereafter, affording an opportunity of the petitioner to be heard before an order under subsection 3 of section 248 is passed. The petition stands disposed of.
Regarding road widening, no notice has been issued. But petitioners are the owner of the scheduled land, they put up a construction of a building, they are residing there. Because now we are responding to authorities without acquiring the land or issuing a notice, they are earmarked the land for road widening.
Earmark.
Yes, madam. They are taking steps. What demolition also, madam?
Yes, madam.
This also report has also-
Earmarking or demolition?
Earmark and demolition.
Earmark ಮಾಡಬಹುದು.
ಅಲ್ಲ, ಮಾಡ್ತಾರೆ, but there is no official proceedings.
Even
ಅಲ್ಲ, next matter is also
next matter.
similar.
It is like you are breathing down his neck and the neck. Find out, madam, no demolition. Then AG accepts notice for respond number 1, 3, 4, 5, and 6. Bagepalli. AC Chetan is directed to accept notice for respond number 2. And AGA is directed to secure instruction as to whether the property of the petitioner is proposed to be used for any road widening and the steps, if any, taken for acquisition thereof. And the respondents are restrained from dispossessing or demolishing the properties belonging to the petitioner till the next date of hearing, released on 10th November. 10th. Party same. And AGA accepts notice for respond number 1, 3, 4, 5, 6. AC Chetan for 2, same order.
For the reason
Rejected. It will get uploaded.
building demolish ಮಾಡಿದಾರೆ. ಈಗ
ಏನಾದ್ರೂ upload will happen.
Serial number 57, adjourn 58. Yes, connected by the.
You are on this side. Good to see you on this side for those things. We'll have it after vacation. We list on 10th, 9th. It's on 10th November. 10th November. Impleading. Who was impleading?
Layout management representation, persons who manage the layout, they are by the application. But I'm keeping a small indulgence from your also. For this reason, that kindly similar, page 53, 54, 55. 53, not very limited prayer making. 53, the top portion is the road which is a public road. Now at the end of the road, Shopa layout, what they have done is, that is the next page. End of the road, they put the saplings to block the way. Now that saplings are becoming small trees now. The kind is the last page, not page number 75. This is my international school. Now I have a road from Manakata. I cannot have the sewage connection. Or therefore, I am seeking a matter is directing the DPNP to remove the structures under the provisions of the DPNP Act. All the time.
This is a public road?
It is a public road. I'm sorry.
Yes.
All I'm requesting now today is, I'll remove these trees and put it in my property. I will not use this road because earlier when the petitioner was filed, there were small saplings. They've already grown to be small trees. I will transplant these trees using the scientific methodology and put it in my property. I will not use this property.
And all these people will come into your property to sit under it.
This is the only road which leads to my.
They made benches and everything to sit there. So if you shift into your property, they should be permitted to come to your property.
No.
To sit and you'll give benches there also.
This is the dead road which was only to my school. Therefore, I
Just
will.
have to see whether it's a public road, Mr. President. Is it a public road or is there?
Public road. When the land was sanctioned, what they have
First,
done
it is a public road. Second, whether this portion is the property of that neighbor of yours. If it is either of them, then we'll have to see.
Property does not belong to the union. Affidavit has been filed on 8/4/21. For limited purposes, the shortage of time, but I'm making consumption. The application they are seeking for shifting of the green. This application they have filed on is posted today, my lord. For that reason, my lord, it is necessary that there is an authority for three authority.
Yes.
That authority is not in a parking.
Whose property is this on which this?
Property is not the property belonging to respondent number 3.
Respond number 3.
Directly file an affidavit. You are kindly moving to the affidavit of 21. The affidavit of Ch16 executed immediately. 8/4/2021. Now, the earlier date, the direction of this one, file an affidavit clarifying the ownership of the property. So in that, it was specifically stated, you know, I say that Kingston is situated on the stage to meter of 12 meters. Width of the said road situated towards the west side of the school. On the northern side of Kingston School, 30 feet width first cross through Veera and Appellate is situated. Gate number 1 and 2 school are located on the northern side. Both the gates are approximately 17 feet width and access to cars and two-wheelers being allowed from the said two gates. To the east side of the school, after residential, there is a residential apartment developed under the name Shobha Petitioner. Respondent number 3 years. Shobha Petitioner has road to the northern side and it's called Shobha Petitioner access road having about 31 feet. The said area was earlier a private road, now brought into the limits of DAP. To the northwest of Shobha Petitioner, to the east of Kingston, there is an island of trees consisting of 22 medium, small grown trees maintained by Shobha.
But whose property is it on which this island of trees is located?
This does not belong to the DAP.
Who does it belong to?
That is a question of fact which has to be decided.
Is it on that access road?
There is no road.
Is access road having width of 9.5 meters on the head? Not on that.
The affidavit which we have, along with the affidavit, photographs also.
Okay, another one. Yes.
That is the main reason of Parliament Road, which has a gate for entry and exit of the buses, gate number 1 and 2.
Yes.
The second page, my lord, is the gate which they are now seeking access to. Second photograph. The lord may now clearly come to page number 7 of the
Yes. Yes.
Here, my lord, the left hand side is the corner which they are seeking.
Yes.
Fully grown gate.
Yes.
Right side is a private property.
Yes.
This space, my lord, this space in between, it is only a pathway, which has a, wherein there is a storm water drain.
Come to page 8.
Yes.
The road up to this island.
Yes, up to this side. Beyond that, there is no road.
You know, this island,
Yes.
if it does not belong to anybody, it's part of that road. If it was a private road and it's come to your jurisdiction, then you are liable for this.
Sir, according to the sketch prepared by the area, there is no road. Up to that island, only there is no road.
Yakendi island ತೋರಿಸ್ತಾ ಇದೆ. The island ತೋರಿಸ್ತಾ ಇದೆ ಅಲ್ಲಿ. Because the island is located there, the road stops. If the island was not there, the road would have proceeded.
There is no road. There is no road. Sketch also.
You cannot have trees, people planting trees on the road, just because it is the corner. And you are not able to say who it belongs to. Where is it? Where is respond number 2 to answer?
Their property.
Respond number 3 is not here to assist. So they are not even bothered about this property. That will come to, that's only a formality. That's a procedure which has to be followed, and if they are going to translocate it, it's fine. We are now concerned with, if this is on the road, then it has to go.
No, no, my submission is that the road ends just at the photograph number at page 8, just behind all your, my lot can see a car parked there.
Yes.
The road ends until there. It is more clear from the other side. My lot turns page number 7.
ಅವಾಗಲೇ ಒಂದ್ರಲ್ಲಿ ಬಂತು ಕಳ್ಳಿ ಸಾಕಲ್ ಗೇಟ್ ಹಾಕ್ಬಿಟ್ಟು ರೋಡ್ನೇ ತಗೊಂಡ್ಬಿಟ್ಟು ಇವಾಗ ಅದೇ ಮಾಡಿದ್ದಾರೆ ಇದ್ರಲ್ಲೂ. Because it is at the edge of the thing, they have planted it.
The moment you page the sketch also, that may also be.
Yes,
So at page number 10,
yes.
not by kindly looking to the. Volume is marked as XX, it's a small.
Yes.
Apart from that is the storm water drain.
Yes.
So now if a road has to be formed, give access to that gate number 3. A road will have to be formed on the storm water drain.
There is already a road on the stormwater drain giving access to this apartment and the private properties.
That's the where is the road.
Yes.
Beyond that, the space. May not be things. That's something. This property does not belong to the.
Already a letter written by BBMP to the three authorities.
Another matter where Mr. Satyanand had appeared, we have directed you to state which of the roads belong to you and which don't. Whenever you want, it belongs to you, we'll take action. Whenever you don't want, it doesn't belong to you.
Oh my God, it's not.
How did those houses come on that road? How did the plan sanctions get happen? The houses, how could they be constructed?
So far as that is concerned, my lord, it was not, it does not.
You can't dissect like that, madam. The entire thing has to be taken together. None appears for respond number 3 today also. So also none appears for the impleading applicants. If none were to appear for the impleading applicants on the next date of hearing, the impleading application would be liable to be dismissed. If none were to appear for respond number 3 on the next date of hearing, the matter would be taken up for consideration on the basis of the counsel for the petitioner. Released on 9th November. That day, they don't claim anything.
Writes a letter to the forest department, please remove this. I have produced along with the application. They have removed, they have.
We have to give one opportunity to respond number 3. If they're not there next time, we'll consider.
Problem is, in the process, they've already grown. It should not become, saplings have become a mini forest, now it becomes a major forest. Then it becomes a right forest. That's
Then Bangalore will be lucky.
lucky.
Okay, Acharya.
Acharya?
Like to appear for the petition, my lords.
9th.
It is for my short prayer for my registration of the Khata certificate. The corporation had to issue this Khata certificate on my sale date. Very short matters. Objection statement not filed so far.
Petitioner is before this court seeking for the following means. The grievance of the petitioner is that the application of the petitioner submitted for
23rd of July.
transfer of Khata on 23/7/2018 in terms of annexure Q has still remained. ಆದ್ಮೇಲೆ ಏನು ಆಗಿಲ್ವಾ?
ಇಲ್ಲ.
It still remained unconsidered. In that view of the matter, any application for Khata transfer file would have to be considered by the respondent corporation in terms of the Sakala so and so within the given time frame. The same not having been done, I pass the following order. The writ petition is allowed, a mandamus is issued directing respondent BBMP to consider the application dated 23/7/2018 as annexure Q within a period of 30 days from the date of receipt. Sakala 30 days.
Please oblige me.
Thank you.
Manmohan PL.
David, after vacation, we list on 17th November. Interim order earlier granted to the by one patient. And 68 to no agenda. Connect with them.
Serial number 63, Vasanta Meyer.
Deputy Commissioner Raita. So just applications are received and NOC is given.
Page 3,
Hmm.
that is GT Dakshina Kannada. So that is with regard to Puttur and Mudapitri. So we are not setting up any firecracker stalls in the government land. That is where the demand for firecracker stalls.
Yes.
So that is only
Puttur and
Mudapitri.
Mudapitri.
Currently, if we are not so pay, in Dakshina Kannada district.
Puttur and Mudapitri. Yes.
For allocation of firecracker stalls, presently applications are looking to issue a policy for the firecracker.
So whenever somebody wants, if they.
So that is not an issue. But the one more issue, my lords, like this, Mangalore, it also comes under DK. So I just corresponded with the council. They say e-auction.
E-auction.
Mangalore
Mangalore
e-auction.
e-auction. Right. Next.
Next would be, my lords, this would be page 4.
Yes.
Here they say, subject to the directions of the board, they are going to conduct the auction.
So would
Para 2, my lords.
Yes.
Then comes the Madikeri members. So previous of the traditional.
Hopefully you'll get more money.
That one already announcement.
Now we'll monitor whether you pay more than the reserve price or not. You have to give all three of them money. The petitioner is before this court. Learned AGA, upon instruction, is filed a memo with letters of the Deputy Commissioner Dakshina Kannada, Deputy Commissioner Udupi, Deputy Commissioner Dakshina Kannada, Udupi, and Madikeri.
No, the third one would be Madikeri. This is Nagara Karyalaya.
Deputy Commissioner Dakshina Kannada and Udupi, and Chief Officer Madikeri, Town Municipal Council. In terms thereof, he submits that in the district of Dakshina Kannada, there is neither a lottery system followed nor a public auction. In the district of Dakshina Kannada, there are no firecracker stalls established on public land, and as such, there is no requirement to either carry out a lottery or public auction. Baki?
Baki very Mangalore, they are telling e-auction.
In terms thereof, he submitted that in Puttur and Mudubidri, talukas of Dakshina Kannada, the no firecracker stall is set up in a public land, and as such no public auction or no allotment by way of lottery or public auction is required to be made. In the event of any person wishing to set up a firecracker stall approaching the jurisdictional authority in Puttur and Muduvudri, the said application would be considered after ascertaining the suitability of the private land and thereafter NOC issued by collecting the relevant charges. Insofar as Mangalore is concerned, it is submitted that a e-auction will be held. Insofar as Udupi and Madikeri are concerned, on the basis of the aforesaid letters, it is submitted that an auction would be held within a period of.
In Udupi, there is Udupi and Kundapur. Udupi district.
Kundapur Taluk in Udupi and Madikeri.
Madikeri is separate. That doesn't come under DC.
And Madikeri city coming under the Madikeri town council is concerned, it is submitted that an auction would be held within 15 days from today. Shri Harish Bhandari, Learned Counsel, who appears for respond number 4, the Commissioner, City Corporation Mangaluru, on instruction submits that a e-auction would be held for setting up a firecracker stalls within a period of 15 days from today. The said submissions answer the grievance of the petitioner which have been raised in the present petition. Placing the said submissions on record, the petition stands dispersed. R11 on this. R11 ಏನು? Sri Chandranath Ariga, Learned Counsel, appearing for respond number 11, Mudbidri Town Municipal Council, in support of the submission made by the Learned AGA, has filed an affidavit of the chief officer indicating that an auction would be held. On inquiry as to the time frame, he submits that the same would be held within 15 days. Answers. Copies are not so. 2022 matter, enough copies are not. That counsel for the petition undertakes to furnish 2 sets of the petition and along with annexures on the counsel for respond number 2 and 3. If the same is not furnished by 26, the petition would be liable to be dismissed for non-prosecution. If the copies are furnished, 3 weeks' time are granted to the respondent to file the objections, which shall be filed on or before 24th November, released on 29th November. Any urgency, Mr. Bhatt?
There is no urgency. It's an executive process.
Then we'll have it later.
Very good.
65 released on 24th November. Meanwhile, in.
Stated are already executed. Petition. No, copy has been sold. Petition has been sold.
You are appearing for which respond?
Please back. Ch16. This question
Is it mainly? It's only correspondence. Whenever then you can challenge that. This is only a communication between them. How are you agreed by this? No action has been taken against you. If action is taken against you, then
AC advertisement was kept present before your lordship's motion.
yes, you were not filed.
Yes.
No instruction. Your instruction one will At the request of the council for the petitioner released on 10th now. It made clear that no further adjournment is given. Released on 24th November.
71. Abhiray Vaiti.
The petitioner was given a contract to verify the quality of works done by the contractors of the Mysore Corporation.
Yes.
I continue to do my work. And the lordship comes to page number. Please come to page number
Abhinay
18.
argued the matter extensively yesterday. Only issue is blacklisting.
No, show cause notice, just black,
Adhe or Kernan. Blacklisting him without issuing a notice, without hearing them. Have you issued any notice? One day. You issue you blacklist them without anything. You take instruction. You will say this. Not even issued a notice. It doesn't even reflect any notice or hearing. They have a tender that they will take on 16. And if you undertake to make good their losses, they'll give you time. Not blacklist, you have a power, but you should issue notice and hear them. The operation execution of the order bearing number so and so dated 12 July 2023 at annexure P, he stayed till the next date of hearing, released on 23rd November, by which time objections to be filed.
'67, my lord, I appear for the respondent.
How's Mr. Gole?
Yes, my lord, I appear for the respondent, my lord.
Which one?
67, my lord.
67 is adjourned to
24/11.
24/11. Now we are at 72.
I am
Consider it. When did you reject it? Yesterday.
Is there not aware of this?
Huh? Is it date and time stamp?
Yes.
This one is not.
Next day, remarks. Forward. Maybe my reason. They applied for even seller. How may have been just details because my amount is there.
Reason ಎಲ್ಲಿದೆ?
Documents not eligible to be rejected.
Unfortunately, you are respondent in every matter. If BBMP comes as petitioner, In those matters, we'll just dismiss it. How can you just say rejected? Reason bedwa? Is there reason somewhere captured or not captured at all? So on online, you don't need to give any, your officers don't need to give any reason.
That we will not apply.
This one don't give. That we told Mr. Sham yesterday only. Within by 25th you will report. And also you will report as to why only reject is there reasons for this. Mad kodappa ನೀವು.
Restriction they are putting on my right to trade.
You were this side until very recently. This is what is happening. You also did not correct it.
Party cannot for this trade license to come and see for matter.
Party dalla. You were this side until recently. So you should have corrected all this by then. You are as much to blame for this.
Gradually that.
They will move it tomorrow.
Just tomorrow that as a matter of.
They,
We will not use it for that much.
given an option, they will move it in the evening only now. The online it will be filed. You have to consider it within 1 week.
The application is still again submit and our fee is already there. We cannot afford it. 55,000 we have already paid.
The counsel for the petitioner has filed an affidavit undertaking that the basement will not be used for any activities other than what is contemplated in law, and that the petitioner will remove all the belongings kept in the cellar, in the basement cellar, within a period of 15 days from today. The counsel for respondent submit that the application for trade license has already been rejected on 29/12/2022. And that a SMS would have been sent to the petitioner. A perusal of the said order only indicates a rejection without any reasons having been provided. The counsel for respondent is directed to inquire and place on record if reasons for such rejection is recorded elsewhere, and if those reasons can be produced before this court. And if so recorded, to produce such reasons before this court. The reason apparently being stated to be the denoting of the usage of the basement for trade activities, the said application appears to have been rejected. In that view of the matter, and in view of the affidavit now filed, the petitioner is permitted to file a fresh application for issuance of trade license. The payment is being already we'll deal with the innocent by making payment of
Possible, I think by just.
Sham, that will take 1 month. If paid, we'll consider it later. By filing a fresh application, by making payment of the requisite fee, the aspect of adjustment or otherwise of the previous fee is left open. The application to be considered within 7 days of filing of the same, released on 25th October.
In the first floor.
the petitioner, since the submission has been made, since an affidavit has been filed, that the petitioner will not carry on any activities in the basement. The petitioner is permitted to carry out the kitchen activities in the first floor without making use of the basement till that day. Previous one, filter.
ಕೆಲವು ಕಡೆ ಫಸ್ಟ್ ಫ್ಲೋರ್ ಬರುತ್ತೆ, ಕೆಲವು ಕಡೆ ಗ್ರೌಂಡ್ ಫ್ಲೋರ್.
Ground stroke first floor. The upload agate, and delivery will be later than uploading. The 15 days parallelly, both will happen parallel. ಏನಂತ communicate? ಇವತ್ತು ಅಪ್ಲೋಡ್ ಆಗತ್ತಲ್ಲ. Yes. No. You want to argue now, your application which you file will also be rejected. You have taken this court for granted. We won't allow that to happen. We are liberal in granting you time. We are liberal in all. Price we have given you time. In argument ಮಾಡೋದಕ್ಕೆ interest ಇಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡೋದು?